Maybe I need to mention listing in read April next week.
It's a fresh matter.
Fresh matter.
Next week. Next week means what?
Regarding settlement.
Next week means what?
7 or 8.
All right, 7th, 8th, whatever you want. 7th laga dena.
Daily list for orders, item 3.
Please, your lordship.
Hmm.
I am appearing on behalf of Mr. H.K. Das, Planning Council, Guwahati High Court. My lord, this is a matter pertaining to a plot of land in Malibagan. As per the Building and Infrastructure Committee meeting, which was held on 23rd of August, my lord, a report is sought from the registry within a period of 2 weeks, my lord. I have
Okay.
a copy of the
Copy of the report of the Infrastructure and Building and Infrastructure Committee dated 23rd August 2023 has been placed on record.
Yes.
The committee has sought a specific report from the PWD roads.
from the registry, lordship.
From the registry. This is agenda item number.
My lord,
Agenda item number
agenda item number 1, my lord. I have 2 copies of the minutes, lordship.
1. That's 23rd August. Now we are having it.
Yes,
It's placed on record.
my lord.
Report from the registry to be placed within 3 weeks. Thus, consideration of this PIL is deferred by 3 weeks for the present.
Obliged, my lord.
A list on 25th September.
Obliged, my lord.
Item number 4 to 7.
Yes, the Supreme Court matter has been decided.
Lordship,
Now the compliance has to be made.
Lordship, some substantial compliance has already been made, Lordship, sometime maybe, my lord,
What steps have been taken? Can you tell us?
Lordship,
Speak out.
Lordship, some documents verification has to be made, Lordship.
Okay, and counsel appearing for the respondents states that steps for ensuring compliance of the division bench judgment are underway and some more time is needed to do the needful. As prayed, re-notify on 16th October. The respondent's contemner shall ensure that the order is complied with in letter and spirit in the intervening period.
Your Lordship, in item number 7, pursuant to the order dated 5/8/2023, we have taken step and awaiting for service.
Mr. Chakravarti, Mr. Patak, are you appearing in item number 7 also for the respondents?
My lord, I would be.
Ms. Patak appears for the contemners in all 4 cases and submits. फिर वो कर दीजिएगा. Copy, please pass on the copy of the contempt petition.
My lord, I have.
Yes.
Deeply honored.
Item number 8.
My lord, I am appearing on behalf of the respondent number 14, my lord. And already we have filed affidavit, my lord. Let it be come up for admission, my lord.
All right. Can be decided right in now and here. You filed a civil suit. What do you want to say?
That has been withdrawn, your lordship.
Doesn't matter. Come out on merits. What case do you have?
Lordship.
What was the nature of your allotment? Who issued the allotment order?
The Gaon Panchayat.
What was the government? Are you sure? Let us see the
The Gaon
receipt.
Panchayat, the Gaon Panchayat.
Let us see the receipt. Gaon Panchayat.
Lordship.
Let us see the allotment order and the receipts. Who executed the lease deed? And is there any provision for 99 years lease deed in the Panchayat area? Show us.
There is such no provision, but there is also not that the Gaon Panchayat cannot do. That is also.
What is the rate prescribed in the law?
Lordship,
Who decided the rates?
Lordship will kindly see
Yes.
This is a case, your lordship,
Uh,
where there was a government land only. There was no government fund, your lordship. So at that time, the Gaon Panchayat initially conducted a meeting, your lordship, the Gaon Panchayat Executive Committee meeting, which is at page number 28, your lordship.
Let us see the allotment order, settlement order. Who has issued it? Whether the panchayat or the president in his own capacity. Who has issued the receipts? And the receipts are for what purpose?
For the purpose of construction of the shop.
Construction of the shop.
Shop.
Why is the panchayat concerned with the amount for construction of the amount, if at all had to be taken, was for the settlement or allotment?
Because there was absolutely no shop also.
No, understand,
was-
sir.
It was
You are
initially
constructing-
decided by you of a Gaon Panchayat meeting, your lordship. Lordship will kindly see for a moment, page
Mr.
28.
Tapadar, tell us
Mr.
if
Last-
if the allotment is to be made, what would the receipt be for?
Lordship, this is a composite thing has happened. Initially, they have
Is there
taken,
any provision in the Panchayat Act that such a composite receipt can be issued? Everything is to be within the framework of law.
but the Gaon Panchayat is a lordship, it is an independent body. They can take some decisions of their
Right.
own, your lordship.
Largesse, state largesse,
Lordship.
can it be distributed in this manner?
No, it was distributed by way of issuing a notice.
Hmm.
After notice, tenders were submitted. After 53% participated in the tender process, and thereafter 29 were selected.
Hmm.
Out, then there were, lordship will kindly see the first resolution of the Gaon Panchayat meeting as page 28.
Yes.
That took place on 12/11/2009.
Hmm.
Lordship, may I read just for a moment? This is the body, Gaon Panchayat body, all the members and the Gaon Panchayat president.
Hmm.
First resolution, the members present in the meeting requested the president to state the agenda of the meeting. The president stated that for the permanent financial development of the Gaon Panchayat, as well as for the engagement of unemployed youth, it is required to construct the shop houses in the east side of the government pond and wanted to know the views of all.
Hmm.
The members present in the meeting resolved the object of the president as acceptable and decided that the said land would be required to be measured and prepared the plan estimate for construction of the building.
Construction of the building. So there was never any approval of selling the shops.
It was unanimously resolved that the application should be required to receive from the
Hmm.
intending candidates within 15 days as per rule of the government and the deed of the-
Rules of the government
and
and the deeds of the agreement be executed by them,
by them.
with them, without any process being followed. Invite applications issued the deeds. What kind of resolution is this? Are the owners of the land?
But the Gaon Panchayat body, your lordship, we have a three-tiered system starting from the
Yes,
central,
yes.
the state and
Tell us, sir, what is the resolution? The resolution is construct a building.
construct a
right.
building.
So under who was taking that obligation? The panchayat. The panchayat said that we'll construct a building. Now you have sold them off. 99 years lease. Was there a resolution to give the land on 99 years lease? There never was.
But there was no,
Who
nothing,
decided the rates?
the Gaon Panchayat decided, your lordship.
Where is that resolution of deciding the rates?
Then page 32, your lordship, the notice was issued.
Read. Hmm.
Page 32.
Yes.
It
Where
is
is
the-
the rate mentioned? Whether it is proposed to allot the shops for 99 years. Whether it is proposed to issue a lease. Whether it was any time the resolution of the Gram Panchayat. Nothing, sir, is a fraud on the face of it.
Lordship, completely a procedure was adopted and the procedure was.
We are asking you, Mr. Council, where is the resolution of the Panchayat that we propose to give these shops on lease basis?
Because the first meeting that I have just read.
Yes, you read it. Read that the shops will be allotted on lease basis.
And the deed of the agreement to be executed with them,
Perpetual lease.
not perpetually.
This is perpetual 99 years.
That
That's
means-
perpetual lease. What else it is?
that is
And who decided the rates?
the Gaon Panchayat body, your lordship.
Where is the decision? Tell us.
Lordship. Then your lordship, the notice was, I just state the facts, your lordship. Notice was issued.
What is the size of the plots allotted?
Showrooms, your lordship, hardly.
What is the size?
Hardly.
Is it to be done by estimation? One may decide to use 200 square meters. Who stops him? I have paid 1,20,000. I'll use 7 big of land for shop.
No, this is.
Then
not
where
like
is
that,
where is that allotment, Mr. Council?
Lordship.
Where is the allotment order? It had to give out the area of the shop.
Lordship, I'll take
The
your lordship to
location.
the list deed which are at page number 141.
Lease deed comes later, sir. Where is the allotment order?
By way of this list deeds, the allotment has been given.
That's great.
By-
Anything else to say?
No, Lordship, you can argue.
Yes, he's here. All right, let him argue. Yes. Where is the sanction for panchayat, sanction of the panchayat for allotting the leases?
Lordship,
Yes,
my lord, first and foremost,
yes.
there was a notice given by the panchayat. I'm coming, my lord. There was a notice given.
Mr. Nair, read the resolution. Does it authorize the panchayat to issue a lease deed?
First resolution.
Yes, page 28.
My lord, this is the prior thing before moving to that exercise, my lord. Thereafter,
Oh, Mr. Nair, there had to be a resolution of the panchayat. In
Okay.
what manner the movement would be made?
the panchayat resolution at page 28, my lord.
Yes, read please. What does it resolve? What does it propose? Where is the plan estimate?
My lord, that I'm just coming to that one. What had happened here? There was a notice, there was a process of selection, and then what happened, my lord? There was
Nair, on what basis? What empowered them to issue that notice?
because
What is the foundation behind that notice?
my lord, the notice was there was a land available to them. They wanted, my lord, that to be put to commercial use. So they invited applications who can invest money and construct. What is happening? I filed a reply, my lord, therein I have said. Now, in all the proceedings before this honorable court, the stand of the government was there is no record. We have got no records.
Yes.
Now, what had
There
happened?
could not have been any
No,
record.
no, my lord, there are records. My lord, what had happened was there was a criminal case, a FIR lodged by the then secretary. He was signing everything. All these documents were seized by the police. My lord. The seizure list, my lord, would find in the report.
Mr. Nair, you have relied upon a resolution of the Gram Panchayat. That
Lordship,
is the foundational fact of this entire exercise, right? Can you dispute that?
my lord, what I have with me is starting point is this resolution.
Starting point. Now,
Lordship.
all right, let us see the notice inviting applications.
Lordship,
Page number.
my lord would find 32, my lord.
Let's read that. Yes.
My lord, this is in terms of that 1211 resolution. It
Hmm.
is informed that for construction of new permanent shop rooms
Yes.
in the northern side of the government pond at so and so, the executive body have resolved that within the next 15 days, the intending unemployed youth may submit their individual application
Hmm.
to so and so and a request
The
along
notice was issued where? Published where?
in the notice board. Huh?
Oh,
Notice.
wonderful.
No,
Is
but
that-
my
is
lord,
that
will
a
see.
compliance?
It's not that, my lord. My lord will have page 34, my lord.
Yes.
The first result, members present in the meeting wanted to know whether the shop room.
President informed. Who is the president to receive the applications?
My lord, we'll look
Yes.
into it. By then, the president informed that there were total 53 applications received by him. The
Yes.
members wanted to know whether it is possible to allot so and so as per land measurement. There are 29 shops possible. One shop room is not possible to be
What was the
constructed.
selection
The
process?
members after, my lord, see,
Mm, Yes.
the members present in the meeting after communication with all applicants primarily selected 29 numbers of applicants as per oral agreement, and it was informed them that there is a requirement of.
How was the selection made, sir? What was the manner of making selection?
My lord, that
How
is-
the 29 people were shortlisted?
my lord,
It is your appeal, sir. You satisfy
no,
the
no, no, my
court.
lord, these records were with the police, my lord.
Mr. Nair, please tell us such a procedure, whether it is permitted under the Panchayat Act. Please tell us.
My lord, panchayat that rules basically pertain to, my lord, settlement of fisheries and all, my lord. This was a new thing, my lord. It was not contemplated under that. This proposal, my lord, this project was not
Yes.
contemplated there, my lord.
Yes.
Then they made a selection.
Hmm.
Then, my lord, we were asked to pay money. We paid to that money was received on behalf of the Gram Panchayat by the president and the secretary. And then, my lord, the constructions were made.
Hmm.
Then proceedings before this honorable court. In terms of this honorable court, we were put into possession of those shops
Hmm.
in 2016, 17, and we are continuing. What had happened was, in the meantime, my lord, there was another application filed, wherein, my lord, there was a direction for proceeding with tender process. This we came up before this honorable court.
Yes.
Division bench. Division bench, my lord, interfered with that and said, now you go back to the honorable single judge and let the honorable single judge take a final call in the matter. Unfortunately, my lord, it was maybe not pressed properly. The honorable single judge said, in view of the order passed by the coordinate bench, this matter has become infructuous. Then there were 2 writ petitions filed before this honorable court.
Yes.
Then, my lord, it so happened that the finding of the honorable single judges, there is no record. And that was the premises. Now we have got, my lord, the materials, my lord, wherein it seems that all these things were seized by the police.
Where was the amount finally deposited?
Finally deposited, my lord, the money, my lord will have page 466. This is the report, my lord.
Yes, 466.
Lordship. Affidavit in reply, my lord, 466.
Yes. And you filed a suit also?
That has been withdrawn. My lord. That was a wrong
That-
instruction given. It was withdrawn, my lord. My lord will have one proceeding book of so-and-so containing page number so-and-so certified by so-and-so using page 1 to 24. Here, all the resolutions are there. One notice dated and issued by the so-and-so, so-and-so. Money received jointly issued by GP president and secretary.
Yes,
so and
whether
so-
it was ever deposited in the funds of the panchayat.
My lord, that's what my
No,
lord
it's
has.
all a collusion with the president, Mr. Nair, apparent. All a collusive exercise with the
But my
president.
lord would see, we
For the department,
my friend will appear.
tell us what is the stand of the panchayat, whether this amount was ever deposited in the account of the panchayat?
My lord, the lease deed was executed by the president in his personal capacity, my lord, which is illegal.
That we know, that we
My
know.
lord would have a finding. of
We
the
want to
judge.
know whether this amount was deposited in the funds of the panchayat or not.
My lord, for that, the records have to be summoned, my lord, which are not in our custody right now. It's in the police custody.
Who is having the records?
It's with the police.
The police, my lord.
Algapur PS case number 249 of 2017.
Okay. All right, who is for the state in this case? To keep the IO present in the court with the case diary. Then counsel, Mr. Your good name, please? B.K. Sharma, appearing for state of Assam, shall keep the investigating officer concerned present in the court with the case diary pertaining to Algapur PS case number
249 of 2017.
249 of 2017. He shall also file and he shall also be required to file an affidavit of the investigating officer explaining the manner in which the amounts received against the allotment of the shops in question were appropriated.
No, I'll give it.
Pass
today.
on the copy of the
Today,
appeal memo,
today,
right?
I'll give it today itself.
Yes. Re-notify on. Even as on date, there are no provisions in the Panchayat Act regarding allotment of land or
And no-
shops or anything
My
like
lord,
that.
there is.
Market, my lord.
47.
There is market.
Any kind of allotment, commercial,
Yes, market is there, madam.
then whether that procedure was followed, let us see. If that was not followed, then everything is otherwise also
But
irrelevant. Let us see the provision.
Assam Financial Rules, Rule 47.
Assam Panchayat financial rules.
Lordship.
Rule,
47. my lord.
let's see.
My lord would say rules and procedure for sale and settlement of markets, ferries, fisheries and ponds.
Yes.
So and so such markets or fisheries as are vested in so and so under so and so
Seal tenders.
seal tenders
Yes.
affecting court.
So where was the seal tender process?
There was no seal tender.
Then
process. It
the
was a
process is
notice
bad.
and my lord,
The
the
process is bad, sir.
53 people applied against that.
Apparently, the process is bad. Why
But
do we
here
need
my
to
lord
do-
would find,
Yes,
here there was no market as such. my lord.
45 days. It was a commercial building to be constructed.
Constructed.
Yes.
And my lord, they did not have money. So they, my lord, invited people.
All right, they had to issue a notice.
They had
Seal
issued
tender.
a notice.
Seal tender process, sir.
My lord,
There was no
The-
seal tender. It was all underhand dealing.
I understand what my lord is hinting at, but my lord would see, this was a
We
peculiar
don't need,
system.
we don't need any record, Mr. Nair, now. This provision is by itself sufficient.
The
I
same
understand.
observation was made at page 312 by the learned single
Single
judge. There
judge.
was no mode of selection. process that
But
took place.
these records were not there in the.
Sue the president, sir. That's all you can do. Anything else to say?
No, no, my lord, no.
Nothing,
That's
this
the view, my lord.
procedure which has been prescribed in the rules has not been followed.
But my limited prayer before my lord is that procedure was not applied because, my lord, there was nothing in existence.
No power with the panchayat to flout or avoid that procedure.
But my lord,
Could
if
not have been done.
I would have understood, my lord, if the panchayat had constructed that buildings, then it would have been a different question. only. It would have-
Immaterial, Mr. Nair, immaterial. Even if they propose that it is, what do you say, self-financing scheme kind of thing.
Lordship,
So a tender had to be invited.
which my lord subsequently happened, my lord, by orders of this.
So then, all right, thank
But
you.
my lord, while my lord understood where my lord is, but my lord, my rights to that
We'll
amount,
save your right to
to that much extent.
you take whatever recourse you
Lordship,
can
lordship,
for saving your rights,
lordship,
protecting your rights, all right,
lordship.
rejected with certain observations.
Much obliged.
Item number 9,
My lordship, item number 9, 10, and 14 can be taken after some time or at 2, my lordship,
Pass over.
highly obliged. But my senior advocate is on his leg, my lordship.
We have passed over the matters on your request. Yes,
10,
10,
same.
10 and 14 also.
9, 10, 14.
10, 14, all of them.
Pass over, pass.
item number 11,
Was there? Petitioner appears in person. Pass over.
item number 12,
One of the affidavit on behalf of the registry has already been filed.
While here we've seen that.
Yesterday
Yes. ma'am.
evening it was served,
Hmm.
so kindly grant us some time. We would like to file a reply on that affidavit on opposition. We received it yesterday evening.
My lord, the whole factor here is,
That
if
we've
there is a
seen.
provision for relaxation of marks, then my lord, she is in, there is
That's
no
right.
problem. But my lord, unfortunately, there is no relaxation
No,
of marks.
no provision as such. And that condition was never challenged.
And that day, on the first day when the matter was moved, my lord, it was moved at 2 o'clock. The examination was the next day. So my
That's
lord,
right.
naturally, to my lord, protect the rights, but it was all with conditions. my lord.
Yeah, it is, the observation is that no
Right,
no lien shall be created.
lordship.
Hmm.
At
All right.
2:30, it was moved, my lord.
Affidavit on behalf of the respondents numbers 2, 3, 4, and 5 has been filed. Affidavit in opposition. Then counsel for the petitioner prays for short opportunity to file an affidavit in reply. Re-notify on what is the status of
My lord, the
evaluation?
Evaluation process is on, so before that, my lord, this would be, otherwise, my lord, this also should be evaluated.
The evaluation process, we make it clear that the evaluation process will continue. However, result of the petitioner will not be declared and shall be kept in seal cover.
My lord can have it, say, my lord, 9th, 10th, whenever.
9th, 10th or Saturday, Sunday,
No, my lord, the
11th.
week thereafter, my lord.
11th.
11th, lordship.
Let it come upon 12th.
12th, my lord.
Yes.
Lordship. Much of this.
Obliged, your lordship.
item number 13,
So far as state of Assam is concerned, we have filed a subsequent affidavit, lordship, it is being filed today.
Mhm.
All the police stations are covered, it is fully functional
Okay.
and we have a storage capacity of 1 month in the police station and in the central server site, it is for 1 year. That is regarding the CCTV.
Mhm.
And regarding the fingerprints, lordship, may I just read it a small paragraph? Affidavit may not be in the record, lordship.
Affidavit,
Yes.
pass on your copy. Let's just have a look at it.
Yes, we have a copy, extra copy.
Please share that. What is the observation regarding that?
Yes, a comprehensive database based on fingerprints, biometrics of every accused person who comes in contact with the criminal justice system is being built in the state of Assam through the central project, namely National Automated Fingerprint Identification System,
Okay,
NAFIS. State Fingerprint Bureau, SPFF, CID organization Assam is the nodal agency for the project conceptualized and initiated by Government of India, MHA, in the year 2019. Till now, a total number of 51 numbers of NAFIS workstations have been functioning at Guwahati and 34 in other districts.
Right.
As of now, 50,017 number of fingerprint of arrested convicted persons of Assam are digitized and uploaded in the central server. So this is regarding the,
Linking it with the e-prisons,
yes, Lordship, then that will be the next, I'll definitely.
that is very important.
Yes.
That is the most important part of it. Once you
The data is here now.
connect it, data is here. It's all electronic data. So
Lordship.
it's just required to be uploaded on a particular platform
Yes,
and assimilated
Lordship.
so that the entire information is shared and it can be used as a
Lordship.
required.
Yeah, the next day, Lordship.
Same thing, yes. Same thing is required to be replicated in Arunachal, Mizoram and Nagaland. That NAFIS. You have a copy of this affidavit and this is when a central project is being undertaken. Why should the 3 other states be left out? Find out, please. And Advocate General, Mr. Saikia submits that affidavit has already been filed on behalf of the state in terms of the observations made by this court on 14/8/2023. The affidavit elaborates the fact that the installation of CCTV at all police stations in the state of Assam has been completed and the cameras are functional. It is also stated that a storage capacity, recording storage capacity of the police station is 1 month, and for the central server, it is 1 year. Regarding the comprehensive database on based on fingerprints / biometrics of every accused who comes in contact with the criminal justice system, it is stated that the process is being undertaken in accordance with in line of the central project, through the central project, that is National Automated Fingerprint Identification System, hereinafter referred to as NAFIS, State Fingerprint Bureau, CID organization, full stop. CID organization Assam is the State Fingerprint Bureau, SFPB. CID Assam is the state nodal agency for the project conceptualized and initiated by the Ministry of Home Affairs, Government of India in the year 2009. 19. 51 NAFIS workstations are functional at Guwahati and 34 in other districts. About 50,017 fingerprints of arrested / convicted persons from Assam are digitized and uploaded to the central server. We appreciate the steps so taken. The affidavit is silent regarding the observation of this court that the biometrics so collected should be assimilated on the e-prison software as well. Learned Advocate General Ms. Saikia submits that this process will also be, the attempt will be made to complete this process by the next date. Then Additional Advocate General Mr. Goswami, representing the state of Arunachal Pradesh, has placed on record a factual report as per which, the till date.
Both of these measures have been comprehensive, the camera surveillance and also for proposal for development of software. Software is what we have. We have written to the government, we have prepared a proposal.
That the process is being undertaken for collection of preparation of the database of fingerprints / biometrics. However, the software has yet to be developed and request has been made to the concerned department in this regard. CCTVs have already been installed in 110 functional police stations of Arunachal Pradesh. However, this factual report is silent regarding the
Later is the 22nd August.
what about the feeds to the centralized control room?
Yes, that is, my lord, that later is the 22nd August. Copy to
22nd August.
6 extra Romans.
Yes, just one. Regarding the feeds of the CCTVs, it is stated that being monitored already.
No, man, for the centralized system not put into place, my lord, for that we have asked for final.
Regarding setting of the centrally located control room, a letter dated 22nd August 23 has been placed on record, which indicates that the said project oblique plan is awaiting allocation of funds. We expect, hope and trust that this process shall be expedited. What about Nagaland and Mizoram?
They are not parties to this.
They are not parties. All right.
Regarding my last submission that it will be completed by the next date fixed.
At the earliest.
At the earliest.
At the earliest.
At the earliest.
Re-notify on. Should we implement the states of Nagaland and Mizoram?
Yes.
In view of the preceding facts, we deem it fit to implement the states of Nagaland and Mizoram in this suo motu PIL. The copies of the proceedings undertaken so far shall be provided, including the pleadings / affidavits, shall be provided to learned Additional Advocate General Mrs. T. Crow, representing the state of Nagaland, and learned Advocate General Mr. D. Das, representing the state of Mizoram. Names of Shri Das and MS Crow shall henceforth be reflected in the cause list. This is regarding setting up a CCTV system, centralized control room in all police stations. So they should be replicated. If already done, well and good, you can get a status report.
Yes. Lord, only one query that I have in my mind, my lord. This is with regard to the installation of CCTV. My lord, since we are dealing with a case originally, wherein, my lord, a mob broke open the jail and took the accused. Now, whether these CCTVs were installed inside the police station and outside the police station, perhaps going by the background, there is no doubt about whether the CCTVs are installed or not, my lord. Since AG has said that.
I think that the state itself would be anxious to ensure that every area is covered. If there is anything which creates a doubt on this, then you have to bring the material on record. What is the location, strategic locations?
I'll have to
You'll find out just
that may be an
informally find out how the cameras are mounted. What are the locations? Whether it is only inside or outside. Maybe the investigation room that has to be served.
And even that is lockups.
Because of the issue, my lord. So
that suicide in the excise.
Yes.
Forest, I think.
Forest matter.
If there had been a CCTV, the things would have been easier. But then that puts a big stress on the investigating officers' use of that Mera Bharat Mahan. You know what is Mera Bharat Mahan? That belt, it bears a inscription, which is used, as everyone knows. Mera Bharat Mahan. Yes. Date.
So far as the Arunachal is concerned, my lord.
Yes.
There was also a direction for expediting that had gone to the registry, my lord. That order I have received, my copy 29/8/23, where the accused didn't appear, my lord, and they were served.
They are still not appearing
before the court, and after service they have not appeared.
Appeared, then let the court will take care. Court will take care. One more thing we'll let you know, Mr. Goswami. we have taken it up on the administrative side with the state regarding the prosecution.
Yes.
The prosecutors are not there. There are 3 prosecuting officers in the state. Teju court we inspected, there are 500 sessions cases, no public prosecutor. We have taken it up on the administrative side. Perhaps you can talk to the consultants.
Yes.
Re-notify on 18th October? 18th October. ये है ना एक वो the पुरखा हाँ सब parted ले लीजिए. Take the parted matter. Let's finish it off.
Supplementary list, item 15 to 17.
Sorry for just troubling your lordship. There is one matter which is part, top of the list, state of Mizoram. And when the
Yes,
applicant
yes.
has filed,
Yes,
so whether your lordship will take. it
definitely.
further.
Once this is over, we'll hear.
Yes, yes.
that matter.
Just, that's why I'm just.
Definitely
Kindly
we'll hear.
allowed your lordship to just go to other courts and.
Please go. We'll call you or we'll wait for you if the matter is called.
If that matter today it was fixed that the records should be here or not. Otherwise, immediately after opening.
Records are available.
There, records are.
Whatever purpose this matter
I have
was
to look,
posted
just
today.
look into the records files.
That relaxation, how it was
Relaxation, yes.
provided, that's what
Yes.
was to be seen from the record. Record is available.
Records is available, I have been told, but I have just had a look into it, what is it?
The limit
So
come up.
we'll re-notify it after,
Yes.
just after opening. As jointly prayed, re-notify on 14th September, rather 19th September,
That's, I think Mr. Chaudhary is there, okay, Chaudhary also. in this.
19th September.
Lordship, 19, Mr. Chaudhary won't be available. Lordship.
When do you want?
2 or 3 days after that.
2 or 3 days. 26th September.
My lord, I will take very short time and try to distinguish, my lord, 3 or 4 cases cited by my friend Advocate General, my lord. I will not read the paragraphs of all these cases. Mr. Nair will read paragraph by paragraph, but I will just highlight certain points of distinction, my lord.
Please do that.
One case referred to was, my lord, Rajasthan Unaided Private School, 2012, volume 6, SCC, page 1. Page 1. He will read the paragraphs, my lord. Otherwise, my lord, it will be repeated reading, my lord.
It's okay.
So I avoid repeating, my lord, the paragraphs, my lord. 12-line paragraphs, 20-line paragraphs. My lord, paragraph 9 and 11, it is a 3-judge judgment basically, and it entirely discusses and gave findings per majority 2 judges. With regard to, my lord, RTE Act 2009, that is, my lord, with regard to right to free education for children. And emphasis till completion of secondary elementary education. And in the judgment paragraph 9 and 11, section 3 of the RTE Act has been quoted, and it has drawn reference to Article 21A. Every child between 6 to 14 years of age, free education. Normally, a higher secondary student or even matriculate student is also above 14 years. 14 years mostly up to class standard
8,
5 or 8, 7 or 8.
maximum 8, yes.
And paragraph 17, my lord, it refers to section 18 of the 2009 RT Act. Schools to, my lord, fulfill norms and standards as specified in section 19 and 25. My lord, here I submit that even otherwise, recognition to specified age, years prior to, my lord, the RT Act came into being. CBSE's, my lord, our bylaws provides for registration and recognition.
By the state.
Yes.
So
from the state.
then who is to do that recognition?
Yes, my lord.
Is a mechanism required to be in place? Who will do it?
State.
In what, under what provisions?
We recognize our affiliated schools and state recognize the CBSE.
No, even your CBSE regulations talk of
Yes. that's what I'm
recognition
saying.
by the state.
That's what I'm saying.
So then who does it? What is the manner?
My lord,
Because I was assuming that this act is not there.
method
Who will do it?
manner I will come, my lord. I'm
Okay.
basically, my lord, on the broad things, my lord.
Mm,
Manner I will come.
mm,
So in this Impugn Act, my lord, this case before your lordship, a different nomenclature brought in, my lord, which is administrative recognition. Recognition understandable, registration understandable.
Mm.
What is administrative recognition?
mm.
Here also lies, amongst other things, my lord, the inconsistency.
Mm.
It talks about administrative recognition. Then paragraph 33,
Mm,
as I said, now I will, my lord, read the paragraphs
mm,
and underlining sentences, my lord, referring to TMPI and Inamdar's case of Maharashtra.
Hmm.
Here, my lord, the honorable three judges talked about reasonable restriction under 19(1)(g).
mm.
Nobody denies it.
19(6). is the-
19(1)(g), Article
Yes.
19, nobody denies it. When I talk about, my lord, right to expression and other rights under Article 19, definitely I will be bound by the reasonable restrictions. My lord. Here also the context is RT Act. And paragraph 38, it extends to registration of unaided schools and recognition, nothing more. And paragraph 68 cited by my lord, my friend Advocate General is a dissenting minority view, my lord, no ratio decident, I will not go into that. The next case, my lord, I will endeavor to distinguish is 5 judges, Kerala matter, my lord, 2012, 7 SCC, 106,
Mm,
State of Kerala versus MAR, Kuri Company. This is on repugnancy and existing law.
Yes.
Here, my lord, I think I will have to read the paragraph 40.
Then
I'll take liberty to read, my lord, some of this. Here I am taking a liberty to read paragraph 40
Hmm.
at my lord. Move it upon there. Addition, paragraph 40, my lord. Lordship may take the move.
just.
Yeah, that was a-
106.
No, go ahead.
दूसरा किताब नहीं है क्या?
15 पेज होंगे ज्यादा।
Yes, please.
Paragraph 40, my lord, at page 129. However, the principle of federal supremacy in Article 246(1) cannot be resorted to unless there is an irreconcilable conflict between the entries in the union and state lists. Said conflict has to be real conflict. The non-obstante clause in 246(1) operates only if reconciliation is impossible. As stated, the parliamentary legislation has supremacy as provided in 246(1) and 2. This is of relevance when the field of legislation is in the concurrent list. The union and state legislatures have concurrent power with respect to subjects enumerated in list 3. Hence, the state legislature has full power to legislate regarding subjects in the concurrent list, subject to Article 254(2), that is, it is emphasis also given here. I also put my emphasis. That is, provided the provisions of the State Act do not come in conflict with those of Central Act on subject. It will be my bounden duty to show the conflicts. So this is, and then question is, it says a state legislature has full power to legislate on the entries of list 3, provided the provisions of the State Act do not come into conflict with such act as always subject to Article 254(2), that is my case. Now, there may be situations, Your Lordship, where certain provisions of a State Act are not in conflict, but yet certain other provisions are in conflict. I repeat, there may be situations where Your Lordships may find that, well, certain provisions of the Impugn Act are not in conflict, but yet some other and certain other provisions are in conflict. The situation may be like this also in these cases. In such situation, even if there contains a single or 2 or 3 provisions of the Act in conflict, presidential assent is necessary.
Here are you reading this?
I am reading it from my submission,
That is your submission.
my submissions.
Even if
After it,
one or two is repugnant, then the entire act has to receive the presidential assent.
if it is so, the question of, therefore, I brought in, my lord, before your lordships, to your lordship's consideration, the question of severability or otherwise, it is bound to come in the final adjudication by your lordships. Then, my lord, I read paragraph 47 of this judgment, Kerala judgment. At page 130.
Yes.
Now, page 130, paragraph 47. The question of repugnancy between parliamentary legislation and state legislation arises in two ways. First, where the legislations, though enacted with respect to matters in their allotted spheres, overlap and conflict. The overlap is one thing, my lord, which cannot be ignored altogether. There can be overlapping, no. It is a pertinent question whether it has overlap and in conflict, conjunctive. Overlap and conflict. Second, where the two legislations are with respect to matters in the concurrent list, there is a conflict. In both situations, the parliamentary legislation will predominate in the first by virtue of non-obstante clause of 246(1), in the second by reason of 254(1). Now, Article 246(1) is conditioned by 254(2). Article 246(1) is conditioned by 254(2). Therefore, my lord, for repugnancy, it's my submission, two situations, overlap and conflict. And overlapping cannot be kept aside and ignored while deciding repugnancy. It is also one of the major factors along with conflict. And conflict, here we have bylaws, the legitimate areas of autonomy are being transgressed and taken over by the Impune Act. And I'll submit that with regard to fee structure also in view of the 2000 Act, there are clear overlapping. Now, paragraph 78, my lord. At page 141, their lordships are summarizing here. To sum up, 246(1)(2), 254(1) provide that to the extent to which state law is in conflict with or repugnant with central law, which parliament is competent to make, central law shall prevail and state law shall be void to the extent of repugnancy. This general rule of repugnancy is subject to 254(2), which inter alia provides that if a law made by state.
What do we mean by to the extent of its repugnancy?
My lord, to what extent it is, my lord, repugnant?
So the entire act will not be repugnant.
May not be 100%, but in many ways it is repugnant. That may be the meaning their lordships have put here. State in respect of matters concurrently is reserved for consideration by the president and receives her assent, then the state law shall prevail. Only when it receives these situations, my lord, the state law will hold field if it receives the assent of the president, otherwise no. More or less same thing as in paragraph 47. Then paragraph 79, lordship, the proviso to 254(2) provides that a law made by the state legislature with the president's assent shall not prevent parliament. Shall not prevent parliament from making any law with respect to same matter, including a law adding to, amending, varying, repealing the law so made by state. Thus, parliament needn't wait for the law made by the state legislature with president's assent to be brought into force, as it can repeal, amend, vary, add assented law, state law, no sooner it is made or enacted. We see no justification in inhibiting the parliament from repealing amending, varying any state legislation which has received precedence assent overwriting with the states, territory and earlier parliamentary enactment in the concurrent sphere before it is brought into force. Parliament can repeal, amend such law no sooner it is assented to by the president, and that it need not wait till such assented to state law is brought into force. The view finds support in the judgment of Tulak. That is a judgment of my lord 1964. I will not go to that, my lord. Here, therefore, basically about the power of parliament, irrespective of any state act, even before their enforcement. Any state acts. Then paragraph 80.
Yes.
Lastly, the definitions of expressions laws in force in Article 13(3)(b) and 372(3) explanation 1, the existing law in Article 366(10) show that laws in force include, this is what I submitted that day. It is not that the conflict is between two parliamentary or two legislative laws, other laws also. Therefore, the include word is very important. It is not compartmentalized between parliament alone and the state legislatures on the other hand. It also means, my lord, and includes the other competent authority made law, including bylaws. Include laws passed or made by legislature before commencement of the constitution and not repeal. Ours is same bylaws. Notwithstanding that any such law may not be in operation at all. Thus, the definition of the expression laws in force in 13(3)(b), 373(2)(3), explanation 1, and 366, existing law. One word is include, and the other dual words are existing law. In 366(10), demolish the argument of the state of Kerala that a law has not been made for the purpose of 254 unless it is enforced. Expression existing law finds place in 254. Court held that there is no difference between existing law and law in force. This is the sentence, my lord. Therefore, I don't think I will have to again go and read, my lord, the text of Article 13, 254, 366(10), and 372(3), my lord. I have read it twice or thrice before your lordship to curtail time. If necessary, my lord, Mr. Naya may read them again. Now, number 3, power to third decision cited by my lord Learned AG, power to put on restrictions on management of educational institutions. State's power to put restrictions on management of educational institutions, as was discussed in a judgment, my lord, AR 66 Supreme Court 1307, Katra Education Society, UP. And as it was referred to and quoted in, my lord, 2016-6, that was what the, my lord's decision cited by AG, 2016-6 SCC, Rajkumar versus Director, Education. This is with regard to, my lord, Delhi Secondary Education Act, which was in question, my lord. So 2016-6, I will only read one paragraph. 2016-6 page to Kimanosil. No.
541.
541. Let's see. Yeah. My lord, let me first submit one thing. Putting some restrictions on the management, meaning thereby the school management committee, the director, chairman, all this principal. Putting, my lord, restrictions on the school management committee is one thing, and to replace the entire management committee or change the management committee of a school by a different governmental managing committee is a different thing.
How do you say? Where?
Because here,
yes,
here in our bylaws, we have 21 members or 23 members, my lord, managing committee comprising so-and-so, so-and-so, so-and-so. Now government has replaced it.
Not replaced it. They said that these members have to be there.
No,
if you want extra members, that's your choice.
No,
that's not barred.
No, they have put an embargo, my lord.
Let's see.
They have put an embargo on there. They have said what type of management committee comprising what number of members will have to be there in your school.
Let's see.
Restriction, allow the managing committee as it is functioning, then impose restriction is another thing. But if you change the managing committee altogether, that is a different thing, my lord. That is transgression. That is taking over. Paragraph 12. Yeah. My lord, 12, page 587.
5H.
587, Constitution of Management Committee. Let her lordship get the page.
Yes.
Let her lordship get the page.
Yes, sure.
Lordship. Constitution of Managing Committee. 1. Every non-government education institution shall, my lord, constitute. It is a dictate, it is a mandate. Constitute a managing committee consisting of the following, namely, chairman, president of the principal managing agent society, headmaster, principal, 2 representatives from guardians, 2 teachers, lecturers, educationist of the locality, 2 members to be nominated, elected by the society or trust. And term of the managing committee shall be for a period of 2 years. Under our bylaws, our term is for 3 years. Term is for 3 years. If for any reasons whatsoever, any vacancy of members occur during the term of it shall be filled up like manner as applicable at the time of constitution of the managing committee. So therefore, it my lord dictates virtually. It is our proven alignment.
Do the CBSE bylaws prescribe some managing committee?
Yeah.
Let us see that. Where is that book, CBSE bylaw? Let us see that. Yes.
Chapter 8.
Chapter
8, 8.2, I believe.
Yes.
8.2.
8.
8.2. If it is telling, my lord.
Chapter 8 is
No, man, I am reading my lord, clause 8.1.
separate.
Bylaw number 8.1.
Yes.
It is not
let us
clause, it
get
is
the
actually bylaw
index.
number 8.1. 8.2.
Chapter 8 is interpretation, repeal and saving.
No, send a copy.
In the book that is so.
I have a book.
2018 only. These are 2018 by.
Yes,
We are having that book.
Yes,
This book.
I have this lordship, subject, it starts with subject to the state law. It starts with that sentence.
Okay. Yes.
My lord, composition of the school management committee 8.2. Management committee of a recognized aided school shall consist of not more than 15 members, and the management committee of a private.
It begins.
I have seen it.
Subject to the relevant provisions.
I have seen it. Having said that, now see the composition of our managing committee.
Yes, let us see what the CBSE regulations say.
My lord, 8.21.
Yes.
Offering
Not more than 15
no,
members.
it's 8.2221.
Yes.
So head of school, 2 parents, 2 teachers, 2 other persons, trust of the society, 2 members nominated by board, remaining members elected, members may be nominated. At least age is important. At least 50% members should be women.
So you can very well manage that even in the
No, but-
scheme of the state act.
But they have curtailed that. They have curtailed that and they have specified the numbers in their act.
But then this has the overbearing effect of this state act, the very regulations of the CBSE,
No, that's right.
the chapter close begins with that condition.
I understand, but it doesn't say that the entire managing committee's composition will be changed. Whatever is the managing committee with 23 members,
So
24 members.
you can very well put forth an application saying
That is
that
where-
we are doing it with the, in accordance with the CBSE regulations. So approve it.
So
They would approve it.
every stage, we need to take permission, even for composition of the managing committee, my lord.
That is what the Education
will
Act
be-
says.
That will be like that, and
Hmm.
they may deny, the director may deny it. Now, my lord. Here,
Read 8.1, please.
then,
Read 8.1.
all the schools affiliated boards shall have a school management committee as stipulated RT Act.
Continue.
Any other enactment regulation framed by state. That's right,
So management committee has to be
as stipulated.
in accordance with. And what you are reading composition is of aided school, not a case of unaided school.
My school is, my lord, unaided school.
So this composition 8.2.1 is of an aided school,
Aided.
not of an unaided school.
I am not,
We are dealing with the case of unaided schools.
no, I am, my lord, not aided school by anyone. I am not aided.
That's what I'm saying. What 8.2.1, the composition you are reading is of aided school.
It will have to be either a state finance or state
So
aided,
please read 8.2.1.
subject to relevant provision in the, or all the schools
8.2.1.
affiliated with the board shall have a school management committee as stipulated.
All right, it says
Right.
unaided school shall consist
Right.
of not more than 21 members. Yes. Hmm.
So the number, we cannot.
The
decide.
outer limit is given 21.
Ah.
It can be less. What prevents you from doing?
We were having more, my lord, and also we were saying that
All right, limit it.
half of it will
There's
have to be.
It's better administration by having lesser numbers, too many which has spoiled the brew.
And we have said, my lord, better things.
Yes,
Half by to be filled up by women, my lord. What is bad in that?
that is right. You can very well retain that. Even in the composition as provided by the state, why can't half of the members be women?
That's right.
What is
And,
wrong?
We have, I believe we have more than 15 or more than 15 numbers, my lord.
Yeah, that's what we are saying. So
So the situation will
just
be.
give it a dressing.
So
Will be a better management.
situation will be,
21 people.
no, situation will be,
Even convening a meeting would become impossible.
no, very fine. The
Yes.
situation is, even with regard to the, my lord, affiliated with the board shall have a managing committee with regard to the stipulation in the central act or a state act. That's right, stipulation. But whether government will, lordship will see whether the stipulation they have made in the constitution of management committee in the Impune Act, it is in conflict of the existing managing committees that we have. I am on that. Not taking the permission and all. So in every stage, if we, my lord, are made to file an application and make a prayer,
So what is it a prestige issue?
no, my lord,
Then-
interference.
Then what is wrong? It's not interference. You give a composition as per the act, they'll have to approve it. Now, the 21 amendments, they have made the director subject to a lot of scrutiny.
They may not approve it. When the
So
provision is there that
appeal
they
is there.
will approve,
appeal is there.
the.
Appeal
that's a
lies in-
different-
And that part,
that
Ms.
is,
Borbora, now under the 21 amendments, the director has been put under many governing provisions.
my lord,
How he has to act.
and one more thing, these restrictions have been, my lord, been by under the RT Act.
Yes,
So it will be, now it is parallelly under the state act also.
not under the RTA, any other enactment.
No, it says, my lord. It says,
All right, let us see.
it says, as stipulated in the RT Act
Yeah.
2009,
Mr.
any
Borbora,
other enactment or regulation framed by.
Mr. Mazumdar, find out what is the composition of managing committee under the RT Act.
Yeah.
It is
So from both sides,
Let's see,
it will come overlapping.
let's see.
section 21.
What is the composition? Read out, please.
My lord, it says a school other than a school specified in so and so shall consist of a school management committee consisting of elected representatives of local authority, parents or guardians of children admitted in such school and teachers, provided that at least 3/4 members of such committee shall be parents or guardians, Provided further that proportionate representation shall be given to parents or guardians of children belonging to disadvantaged group and weaker section. Provided also that 50% members of such committee shall be women.
All right, so your management committee is running foul of RT Act even.
Then
Now what to do?
under the rules.
Yes.
framed,
Hmm.
My lord, it's the school management committee rule 13(1) under the RT Act state rules. It says a school management committee shall be formed by each school. This would be a permanent body of which the president and members will have 3 years. However, they shall contain 9 members shall be from parents or guardians of the students of the school in the following.
So they will modulate the provision accordingly as per the RT Act. They'll have to do it.
We'll have to do it.
Just one clarification. If section 21 starts with a school other than a school specified in subclause 4 of clause N of section 2. Lordship will kindly come to see. So this committee will not be applicable for unaided.
Unaided schools, yes.
And the page 7, the definition of school says, school means any recognized schools imparting elementary education and includes Roman 4, an unaided school not receiving any kind of aid or grant to meet its expenses. So this composition is not applicable to unaided schools.
Come to next, my lord.
All right.
I'm coming.
Very well.
The other decision cited was, my lord, Karunanidhi's case, my lord, 79(3) SCC 431. This is also on repugnancy and 254's interpretation. 79 today.
Yes.
Here, my lord, the paragraph cited were 79, page 431.
Yes.
439, paragraph 7 is the 5 jazz, my lord. Paragraph 7. I am reading paragraph 7.
Yes.
We propose to deal with 2 arguments separately. We first deal with the question of repugnancy as raised by Council for Appellant. It's true that State Act was passed by legislature of Tamil Nadu and the assent of President was obtained. In this case, my lord, it was there. By virtue of provisions of 254(2), since the assent of President had been taken, given the State Act was to prevail over the Central Act, so far as the state of Tamil Nadu was concerned. But the serious question to be considered is whether or not there is a real repugnancy resulting in irreconcilable inconsistency between the 2 acts. Now, 254 is produced here, 254, 1 and 2, it is quoted and reproduced here, my lord. And when it says, my lord, then I will read paragraph 8 also. It would be seen that so far as clause 1 of 254 is concerned, it clearly lays down that where there is direct collision between a provision of law made by state and by parliament with respect to one of the matters enumerated in the concurrent list, then subject to the provision of clause 2. It is clause 2 where the words or existing law, your lordship will find. The state law would be void to the extent of repugnancy. This naturally means that where both the state and parliament occupy the field contemplated by the concurrent list, then the act passed by parliament, being prior in point of time, will prevail, and consequently the state act will have to yield to the central act. In fact, the first scheme of constitution is scientific and equitable distribution of legislative powers between parliament and state legislature. First, regarding the matters contained in list 1, parliament alone is empowered and the state legislatures have no authority. Secondly, so far as concurrent list is concerned, both are entitled to legislate in regard to any of the entries appearing therein, but that is subject to the condition laid down by 254(1) discussed above. It is always, my lord, circumvent and conditioned by. Then thirdly, it is not doesn't arise, my lord. It is state list. Now 1, 2, 3, 4. It is therefore obvious that in such matters, repugnancy may result from the following circumstances discussed. Where the provisions of a central act and a state act are fully inconsistent and are absolutely irreconcilable, the central act will prevail, the state will become void in view of repugnancy. 2, Where, however, a law passed by a state comes into collision, it is, my lord, yet another new word. Actually, it is an old decision, 79. Collision is the word used. With a law passed by parliament on an entry in concurrent list, state act shall prevail to the extent of repugnancy and provisions would become void, provided, this is again, it is mentioned, provided the state act has been passed in accordance with clause 2 of the article 254, presidential assembly. 3, where a law passed by state legislature while being substantially within the scope of the entries in the state list entrances upon any of the entries in the central list constitutionality of the law may be upheld by invoking doctrine of pith and substance, and if on analysis of the provisions of the act, it appears that by and large, my lord, emphasis, by and large, the law falls within the four corners of the state list, and entrancement, if any, is purely incidental or inconsequential. Here, it has multi-dimensional consequence, my lord, in our case. Where, however, a law made by the state legislature on a subject covered by concurrent list is inconsistent with the repugnant to a previous law made by parliament, then such a law can be protected by obtaining the assent of presidential assent under 250. It gets the protection only when the president gives the assent, otherwise not. The result of obtaining assent of president would be that, so far as the state act is concerned, it will prevail in the state and overrule the provisions of the central act in their applicability to the state only. To the state only. Such a state of affairs will exist only until parliament may at any time make a law adding to or amending, varying, repealing law made by the state legislature under the provision 254. It will exist not for all time to come, but until the parliament makes a law, my lord. This vital postulation that gives prevalence of and legislative legitimacy, my lord. This paragraph. Obtaining a precedent, getting the assent would be, so far as the act is concerned, will prevalence. So these are the vital postulations that give prevalence, and not only prevalence of a state act, it also will have to be in connoissance with the legislative legitimacy. Now, therefore, my lord, when it says law made by parliament is essential corollary, the essential corollary would be that existing law before independence and carried over after independence. Before independence, when there was no parliament. It is both with regard to pre and post independence that the framers ordered Article 13, 252, 366, etc. All have to be read together and not in isolation from each other constitutional provision.
All right.
Then, my lord, paragraph 24. It is well settled, page 444. It is well settled that presumption is always in favor of constitutionality. Yes, it is a known case. And onus lies on the person assailing the act to prove that it is unconstitutional. Right? Yes. Prima facie, there doesn't appear to be any inconsistency between the act, central acts. Before any repugnancy can arise, the following conditions must be satisfied. 1, 2, 3. I, my lord, 3 refer to that inconsistency between provisions of the two acts is of such a nature as to bring the two acts into direct collision with each other, and a situation is reached where it is impossible to obey the one without disobeying the other. Now, my lord, I submit what situation is created and emerged by virtue of the Impune Act could be found in thorough clause by clause, subsection by subsection reading of the Impune Act here. You will again go and repeat all this. If necessary, I will again refer to, so as to convince. The Lord says that the name of restrictions, there has been a definite attempt, number one, to transgress, take over entire day-to-day management of the CBSEs. Entire day-to-day management of the school, not getting permission here and there, exposing ourselves to some check and balances by that. Actually, my lord, the act, reading the clauses, my lord, and the sections and subsections, it appears and it is apparent that it actually interferes with the day-to-day affairs of the And number three, many replacements made in the garb of restriction do not come within the meaning of reasonable restriction. If you want to replace this, replace that, it will not do, it will, that will have to be in consonance with the constitutional provisions and other legal provisions, and also, my lord, they must not be in the garb of restrictions. And number three, overlapping, as I submitted, it is something which entirely cannot be ignored. Paragraph 28. Is a Bombay case, old case, my lord, 55, referring to that. This court laid down the various tests to determine inconsistency. The important thing to consider the reference to this provision is whether the legislation is in respect of the same matter. If the latter legislation deals not with the matters which form the subject of the earlier legislation, but with other and distinct matters, though a cognate and allied character, it is not here in my case, my cognate and allied character, then 254(2) will have no application. In our case, there is nothing like cognate and allied character. These bylaws. The principle embodied section 107, article 254 is that when there is legislation covering the same ground, both by center and by the province, both of them being competent to enact the same, law of the center should prevail over that of the state. It is true. Now this paragraph. It is true that as already pointed out, that on a question under article 254(1), whether an act of parliament prevails against a law of the state, no question of repeal arises, but the principle on which law of implied repeal test rests, namely that if a subject matter of the latter legislation is identical with that of the earlier, so that they cannot both stand together, then, so the question is not conflict. Question at times is also mutually, whether they are mutually exclusive, overlapping, and mutually exclusive. That if the subject matter of the later legislation is identical with that of the earlier, like fee structure, they have an act separate. RTE Act is there already in place by the central government since 2009. All these things will have to be considered before they say that, well, this is the act, these are our objects, and therefore we are enacting it. That if the subject matter of the later legislation is identical with that of the earlier, so that they cannot both stand together, then the earlier is repealed by the later enactment will be equally applicable to a question under 254(2), whether further legislation by parliament in respect to the same as that of the state law. Then paragraph 33. Yes, these are paragraph 33. Here, my lord, citing a 1964 case, Odisha. Repugnancy arises when two enactments, both within the competence of two legislatures, collide, and when Constitution expressly or by necessary implication provides that enactment of one legislature has superiority over the other, then to the extent of repugnancy, here also the extent of repugnancy is there. It may not be total and 100% repugnant. There may be, it may be repugnant to certain extent. The one supersedes the other. But two enactments may be repugnant to each other, even though obedience to each of them is possible without disobeying the other. So I follow the provision of RTF Act. I follow the fee structure as laid down by the Supreme Court in Modern Schools case. I follow the various postulations of TM Pai case, and yet I have to follow the postulations made by them in the new Act, Impune Act. The test of two legislation containing contradictory provision is not, however, the only criterion of repugnancy. For if a competent legislature with a superior efficacy expressly or impliedly evinces by its legislation an intention to cover the whole field, the enactments of the other legislature, whether passed before or after, would be overborne, meaning overlapping on the ground of repugnance. Where such is opinion is the position, the inconsistency is demonstrated not by detailed comparison of provisions of the two statutes, but by the mere existence of two pieces of legislation on the same subject matter. 34. In the case of Balia versus so and so, my lord, again in 1969 case, it was pointed by this court that before coming to the conclusion that there is a repeal by implication, court must be satisfied that two enactments are so inconsistent that it becomes impossible for them to stand together. In other words, the court held that when there is a direct collision between, the collision word comes here also, my lords, like in the 79 judgment. Collision between the two are repeal, satisfied that two enactments so inconsistent that it becomes impossible. In other words, court is held that there is a direct collision between the two enactments, which is irreconcilable, then only repugnancy results. In this connection, the court made the following observations. My case before your lordship is that in my case, our bylaws are galloped by the Impugn Act almost in its entirety. Our CBSE bylaws made virtually redundant with so many restrictions and translations overall. Before coming to the conclusion that there is a repeal by implication, court must be satisfied that two enactments are in so inconsistent repugnant that they cannot stand together, and the repeal of the express prior enactment must flow from necessary implication of the language of the latter enactment. It is therefore necessary in this connection to scrutinize, my lord, the terms and consider the true meaning and effect of the two enactments. On the one hand, the other act, Central Act, one hand the Impugn Act. The provisions enacted in section 52 of the 1922 Act do not alter the nature quality of offense enacted in section 177 IPC. 177 is furnishing false information. But it merely provides a new course of procedure for what was already an offense. In a case of this description, the new statute is regarded not as superseding, not repealing by implication the previous law, but as cumulative. A plain reading of the section shows that there is no bar to the trial or conviction of offender under both enactments, but there is only a bar to the punishment of the offender twice for the same offense. In other words, the section provides that where an act of omission constitutes an offense under two enactments, the offender may be prosecuted and punished under either both enactments, but shall not be liable to be punished. It's different. In these cases before, your lordship, in my cases, there are stars, my lord, anytime, day or night, or noon or afternoon, morning, and seizure without court's order, my lord. And these appellate provisions will not go, my lord. That is a criminal action, my lord. There is a criminal action. I'll have to go to, my lord, for a criminal revision. Paragraph 35, my lord. On a careful consideration, therefore, the authorities referred to above the following propositions emerge. That in order to decide the question of repugnancy, it must be shown that two enactments contain inconsistent, irreconcilable provisions so that they cannot stand together or operate in the same field. Two, there can be no repeal by implication unless the inconsistency appears on the face. It is there that where the two statutes occupy a particular field, but there is room or possibility of both statutes operating in the same field without coming into collision with the other, no repugnancy results. Here, my lord, the fields are not only fees, security, terms on tenure, etc. They go far beyond, my lord. So thus, from all these Supreme Court judgments, 2, 3, 5 judges, one thing is clear that since 1950s till date, the question of repugnancy, my lord, which regard to list 3, and the language of the all-important, my lord, constitutional provisions like Article 13, 254, 366, 10 are all standing with their heads high, my lord. And my lord, none of these good old decisions, my lord, ever overlooked, only cited, interpreted time and again. Well, my lord, here, I don't dispute that nobody should, that there must be adherence to some minimum. Why I say minimum, I'll submit, my lord, because the question of autonomy is also recognized by Supreme Court. Protection with respect to tenure of school teachers, principals over, nobody denies procedural guarantee, my lord, nobody denies the, my lord, good old, my lord, Latin principle of, my lord, OD alteram part-time. Nobody denies. It is,
Nobody denies then how it is to be structured.
no, we are also not going. We will have to follow. That's what I'm saying.
What would you have to follow?
And a code of conduct is there, disciplinary, my lord, proceedings. There is a chapter in the bylaws, my lord. OD alteram part-time will have to be there. That's what I am meaning, my lord. CBSE bylaws have all along, my lord, followed this. In service discipline, teachers, employees. Yet after, my lord, following all these basic niceties of, my lord, legal requirements, there still would be certain queries, certain questions. While, my lord, private unaided schools are to ensure security of tenure, minimum salaries, more or less codified condition of service regarding suspension, retrenchment, dismissal, termination, simplicity. My lord, question will be, my lord, can we be made to give or compelled to give, say, for example, pensions after retirement, pay revisional benefits like government establishment, schools or otherwise. Can you give, my lord, can you not give, my lord, voluntary retirement? Analogy to, my lord, Industrial Dispute Act, that cropped up that day, my lord. It will not, my lord, this act will not step in here because, my lord, our staff teachers are not workmen.
Not the teachers,
Not
the other staff,
Yeah.
grade 3, grade 4.
Maybe. So generally, my lord, the workmen as defined in, my lord, industrial parlance and private tea gardens, lordship was referring, they are subjected to, they are to do many things, my lord. Hospitals, ESIs, industries. Here they come under the ESI Act also. Can all this be extended to, my lord, these schools like Delhi Public School or CBSE schools? Termination simpliciter is a valid provision under various state laws, my lord, central laws. I don't like it. But in the Food Corporation of India Act also there is a provision. I fought out cases, my termination simpliciter. Give a check for 3 months salary in lieu of notice. Terminate from 1st of September. So what I mean to say that even here a state cannot put, my lord, all pervading domain controls, my lord, on us by the Impugn Act intended to virtually take over the control and discard all existing mechanism that we have been following over decades and decades, my lord. Now, my lord, about various, my lord, inconsistencies before Nair comes in, my lord, my lord, say one thing. After this, I will conclude for the time being, my lord. We must not also lose sight of one vital financial aspect. Any state government has a budgetary provision for educational sector like other sectors. The yearly budget earmarks, my lord, several thousand crores for the education sector.
Yes.
Funding and financial, there is always funding and financial backup for all government schools. Irrespective of the fact that very often then that they are wasted. Yet, see the plights of the government elementary schools, my lord, and higher secondary schools. See the plight of, my lord, regularized and non-regularized teachers of at different levels. Tenure, security, tenure. There are, my lord, thousands of non-regularized teachers working in various government schools with a lump sum, my lord, pay. And there are cases galore before this High Court. Thousands of teachers have been working. These are all cases, my lord.
There can't be negative.
No, I don't say that our teachers should be also like that. Many attain age of superannuation that way, my lord, in government schools. As against such eventualities, my lord, unaided private schools don't have any backup budgetary allotment from any quarter. We are to survive on our self-generated limited fund and yet try to be charitable.
That is what the Supreme Court says.
My lord,
That is what the cardinal principle is.
one thing, I think your lordship will be called upon for the first time The word profit has time and again been spelled out by various judgments cited. Now, none of the judgment says what constitutes profit in a financial transaction, earning and expenditure. What constitutes profit? None of the, maybe your lordships will be called upon to define that. Now, say, for example, cooperative societies, they give dividend. Dividend means profit to the shareholders. We, the school, we don't pay any dividends, but forget the word profit, forget the word charitable. If we do not have some surplus money, how can we go for expansion of our infrastructure? That there should be another wing building to be constructed to absorb additional number of students, 3-story buildings. That will be expansion of the school. So there will have to be some surplus. We don't divide amongst the my lord managing committee members like dividends. That's what I am, my lord, submitting, my lord, because it is rational that we don't sweepingly make unequals equals also in a way. There will have to be at stake. We cannot, my lord, be equated with the financial standings of government schools. And it cannot be extended to all and sundry aspects, my lord. That is what I submit, my lord. Let's only continue, my lord.
My lord has heard the matter from both sides. Judgments have been placed before my lord. I'll not trouble your lordship with any of those. My endeavor would be only one judgment of old judgment of 1989. My lord, from the first day I was trying to place before my lord that this act is a half-baked one. It does not have the means in itself, or the legislature has not put into it the manner and method in which, my lord, it says the act is not only to recognize, it is also to regulate the functioning of the school. The recognition, there is some process, but for the management or the school to be monitored over the period of time, my lord, will find no provision. The argument that can come up before my lord is that, I mean, it has come up, that while we ask for recognition of the school, the documents or the materials which we ask for recognition of the school, that by itself is enough to show that whether the school is functioning or can function in the manner required. The second aspect is, my lord, my case before my lord is that irrespective of the fact whether it is being applied to a CBSE school or a state board school, the powers that are given to the authorities under the act is not channelized. My lord, it says that I have to comply with any order that may be passed. I'll show, my lord, how this has to be done, because there are subsequent legislations which have come into, which are holding the field pertaining to this, at least a part of the act. Now, my lord, under the RTI, class 1 to class 8 is covered. And RTE Act is by the central government. The states, specifically under section 38 of that act, have been given the power, specific power. And it's one of the act, my lord, wherein the power to make rules are being defined with relation to the sections. My lord will see there how the rules have been made, how flowing it is, my lord, how the principles of natural justice, the arbitrariness, whims and caprices have been taken care of. Now, here the reply that has come before my lord is, as regards this act, we have an appeal provision which we have brought in 2018. Now, I'll demonstrate before my lord that appeal provision is a non-est one. It cannot even be applied. I'll take my lord straight to the act, my lord. Just trouble my lord with a few provisions and then my lord take my lord. My lord, we'll have section 3, man.
Yes.
My lord, here the power is on the state government. My lord, will have it. The state government may regulate all non-governmental educational institutions in the state of Assam in accordance with the provisions of this act and rules made thereunder. On and from the date of commencement of this act, the establishment of non-governmental so-and-so, and opening of higher class or closing down of any existing class in any existing non-governmental institution shall be subject to the provisions of this act and the rules made therein, and any governmental so-and-so or any higher class established or open otherwise, then accordance with the provision shall not be recognized under section 5 and by the director and shall be closed down under section 24. So, my lord, the only penalty other than my lord 25, there is a provision in 25. The only penalty that here is that we will close down.
Yes.
Then my lord 4 is with regard to the new institutions. 6 is with regard to the existing institutions. Not trouble my lord with the thing. 10, section 10. My lord, is the requirements.
Yes.
Here, my lord, would find it's broad. It's been given. And my lord will only have 17, my lord. Roman 17,
Just
10.
one question at this stage.
Lordship.
Yes, kya? One question you will have to answer. Yes, kya? Section 10, if you look.
Lordship.
A person who's supposing having a rented property,
Lordship.
can't that person open a school? This provision says so.
Yes, Lordship.
Owned.
Yes. There is a reason for that.
Yes.
If you look at from the Assam's perspective, this is very important.
Why?
Because we had flourishing of large number of venture schools where one family is showing 3 schools in the same campus. So all these things were taken into consideration here.
Why a leased property or a rented property can't be used for a school? What is wrong in it? Why an owned property only? That is unreasonable restriction. I have a 99 years lease from someone.
Yes, own and possess a minimum area with clear title of the over it as
Yes,
specified.
title, clear title. So it's a leasehold. I have a lease. In Rajasthan, there is a system of municipality granting lease. 99 years. So that is not owned. Neither it is a title.
So now that clarification may be given, Lordship, that lease including absolute ownership.
The court reads into the act certain
The substitute.
parts that these are not good. So we read into this. So you just take a note of it. Since one by one the sections are being threshed out. So some things which have come out, we may address that.
I'll address, Lordship.
Yes.
We are noting it.
Yes.
My lord, 1, my lord has seen. 3 now, my lord. Roman 3. Institution shall follow approved courses and curriculum as provided in this act. This is not even provided. They just say subsequently that it will be as per the affiliating bodies. Now, but this is one of the condition I'll have to fulfill without that being prescribed anyway. Then my lord would come.
Does the act say that these courses and curriculum will be as per the affiliating body?
Yes, my lord. Section 17, my lord.
Then where is the need to
fulfill that? That's why I said, my lord. At that point of time, the intention was good, my lord, but the execution was bad.
Operation successful, patient dies.
Dies, my lord. And I'll show, my lord, how it will die.
It's okay. Yeah, carry on. Yes.
Then, my lord, 17, my lord.
Yes.
My lord would see
Yes.
there is no definition of this, but a very wide thing has been said. The institution shall furnish such reports and information.
Section 17.
No, my lord. 10 Roman 17.
10 Roman 17. Just. Yes.
The institution shall furnish such reports and information as may be required by the director from time to time and comply with such instruction of the director as may be issued to secure the continued fulfillment of condition of recognition or removal of deficiencies in working of the institution. Now, how this thing would be worked out, the legislature, while granting that power, has not
Such reports. What would be the report?
But we don't know. It can be anything. He can ask for anything. He can even ask for me that teacher, you have given him leave. Why didn't you give this man a leave? But I'm just trying to, it can go to that extent, my lord. That power is arbitrary, my lord. Arbitrariness can come in. Now, my lord, we'll see 18, Roman 18. All records of the institution shall be open to inspection by an officer authorized by the state government or the director as the case may be at any time, and the institution shall furnish such information as may be necessary to enable the state government or the director as the case may be to discharge their duties and functions in accordance with the provisions of this act and the rules made thereunder and or any law for the time being in force. Now, my lord, what are the requirements? What would be the situations and how those situations would be dealt with? It's not here. And I'll show from the RT rules, my lord, it has been defined. The process has been given. And in the rules also, my lord, will not find anything to this connect direction. The next one is very good, my lord. Every government, non-governmental institution shall make an
regional languages, cultural language.
And that is already provided for by the language acts. Then, my lord,
so this is just an act of consolidation.
Consolidation. My lord, will have 21, my lord. Roman 21. Now here, these are the conditions we have to fulfill for establishment. Now, my lord would see 21. Such other requirements as may be prescribed not inconsistent with the provisions of this act. Now you have given everything here. Now you can also in a given situation, think about something and ask, which may be very impossible for us to make. Now, management, I am leaving it, my lord. My lord will come to 14, section 14, my lord. This is the heart of the act. The managing committee shall frame a scheme of management for the institution containing the salary structures and other conditions of service of employees and the fee structures in all levels of education, amongst other things, as may be prescribed and which shall not be inconsistent with the provisions of this act and the rules made thereunder, and shall submit the same to the director for consideration, acceptance, and record. Today, my lord, we have the rules. But when the act came into being, these prescriptions were not there. And the prescription is not here. It's not what is to be defined in the rules. It's beyond that also, madam. My lord, if I may just, the managing committee shall frame a scheme of management for the institution containing the salary structures and other conditions of service of the employees and the fee structures in all levels of education, amongst other things, as may be prescribed. So there has to be a prescription in this direction along with the act. It then says, and which shall not be inconsistent with the provisions of this act and the rules. It does not say, my lord, as may be prescribed in the rules. Made therein shall submit the same to the director for consideration, acceptance, and record. 2, my lord, no levy of any kind of fee shall be made or imposed by the institution in excess of the fees as fixed in the scheme of management, except with the prior approval of the director. The director may approve or disapprove the proposed increase in fees if he is in opinion that such an increase is necessary due to increase in the facilities provided, and may disapprove for reasons to be recorded in writing. The scheme of management shall provide educational qualification for the teaching staff of the institution, which shall conform to the educational qualification as fixed in respect of government, provincialized, primary, middle, secondary, higher secondary level, as the case may be. Now, my lord, 1, 2, and 3 basically relates to that fee and the payment of salaries. Payment of salaries nowhere prescribed, that you have to pay this much amount. Fee, my lord, has already gone through that 2017 Act, which is a self code on itself. It takes into account everything. I'll place that, my lord. Wherein, my lord, the manner has been prescribed. The particulars that are required have been prescribed, and thereafter the way in the decision will be taken has been prescribed. And by giving that body the power under, my lord, the CPC to examine witnesses, call for documents, is also placed in that body. And that act is in conformity, my lord, with TMPI, Imandar, Delhi Modern School. So to that extent, this provision, my lord, cannot exist. Because when we are required to go in terms of the Supreme Court orders and have a fee, that fee that we demand, done by a committee, and the process is fixed, my lord, we should not be required now to go back to the director. So section 14, if section 14 goes, my lord, the whole act will collapse. Now, my lord. Now the interesting part, my lord, section 15. It says appointment order, very good, my lord. No, there cannot be no doubt on. A person should be given an appointment order, whether it's in private, public, wherever it's. Now, my lord, we'll have to. No employee of a government education institution shall be dismissed, removed, or reduced in rank or terminated without giving him a reasonable opportunity of being heard and without the matter being referred to the managing committee for its consideration and approval, provided that the school authority may suspend an employee with immediate effect without such prior approval of the managing committee if it is satisfied that such immediate suspension is necessary by reasons of his gross misconduct under the code of conduct framed under section 16. Now, my lord, I pause here for a moment. There was a decision placed before my lord pertaining to Delhi. 8.2 of the Delhi Education Act was brought into it. 8.2 is a code in itself. It says you can terminate anybody, but you come to me and inform me. It may not be that he'll have to examine, but inform me. And therein it was whether, my lord, they went with the Industrial Dispute Act. The Supreme Court said, no, you have to apply 8.2.
8.2, yes.
My lord, where is 8.2 here, my lord? Now the teacher, my lord, I'm because it's an act which my lord is examining. Let us also examine it from the point of view of that teacher, my lord.
Yes.
Now the teacher today is, my lord, done away with. Where will he go, my lord? Nothing has been provided here.
And what is the procedure prescribed?
Procedure prescribed is in the rules, my lord, it says that there will be a, my lord, penalties. Disciplinary committee, that disciplinary committee will heal, but my lord, it does not, after that, it does not make anything. So once that school does it, where will that teacher? Because you are regulating
to the teacher.
You are regulating. Once you are regulating, that teacher must also be given an opportunity. It's not there, my lord. That's why I said the act is without limbs, my lord.
Yes.
And I'll show from the appellate provision. Appellate provision, none other than the management can go, my lord.
It is the other way around.
It's other.
Okay. Yes.
And this procedure has been prescribed, no problem.
Because fortunately or unfortunately, this disciplinary action does not require approval of the director.
No. But, my lord, if they say that they are very much concerned, because the statement of objections that the teachers are dealt in a very bad manner.
Very bad manner.
If the state was concerned with that, my lord, this is not the act which should have been there, my lord. Now, my lord, curriculum syllabus, my lord, has...
Mr. Nair, 28 says any individual. All right, that is the order of the director which can be challenged.
I'll show that.
Yes,
I'll show that. I'll show that.
Okay.
What that individual
Carry
is.
on, please.
Then, my lord,
Hmm.
now come to my lord, page, section 20.
Yes.
Nothing can be more vague and arbitrary than this, my lord.
Hmm.
The director or any officer authorized in this behalf,
Hmm.
until here, my lord will not find any provision as to how the whether the acts and all are being monitored, done, everything is done, how it should be looked into, my lord will not find. Recognition, administrative recognition, that's the end of the matter. Then you give me the scheme with the fees.
Hmm.
Thereafter, there is nothing, my lord. Now this provision, my lord.
Hmm.
The director or any officer authorized in this behalf may enter at any time with or without notice any place or places in the premises which she has reasons to believe is being used as a non-governmental education institution.
Hmm.
So, my lord, this has got nothing to do with the act. So, if anybody is running a
Any
school,
building,
any building can go in, my lord. So, nothing to do with that.
Hmm.
Make such examination of place, building or premises, or inspect any place, building or premises, equipment, articles, documents, including financial transactions, seize any such equipment, article, documents deemed necessary for the purpose of examination, investigation, or collection.
Hold on. Now, yes.
What is
This
this?
is a very interesting. Which building?
Where?
Which
If I read
building?
it with
Any building.
any building, my lord. Nothing to do with the purpose of achieving the object of the act.
This doesn't even, subclause B doesn't even talk of a building which is being used
As an
non-government educational institution.
So, my lord, you are making an act.
Yes.
Then, my lord, after making the inspection, the director or his authorized officer carrying out the inspection shall furnish a copy of the inspection report to the manager, managing committee of the non-governmental education to act upon the report and compliance. What can be more vague? And, my lord, see the power which is being given,
Hmm.
which can be put to misuse.
We had put a question to Mr. Iken.
Lordship.
This seems to be highly arbitrary. Yes, surprise inspections as per the Supreme Court judgment permissible. But power of seizure,
my lord,
absolutely unacceptable.
my lord, there has to be.
On the face of the record, even the police officer cannot seize anything unless there is an information of a cognizable offense being committed.
Lordship.
Or there are provisions under the Copyright Act, supposing.
Lordship.
There are specific provisions dealing with offenses. These are not offenses. Their non-compliances have their own consequences.
My lord, I'm going towards, my lord, Pan Bazaar. Don Bosco school falls there. Okay, I'll just go in and get it. It would be to that extent, my lord, I can say. I'm sure the state officers will not act in that manner, but the possibility is there, my lord.
Possibility is there, yes.
Now, my lord, utilization of fund. Now, audit and accounts. 22(1). The accounts of a non-governmental education institution shall be maintained and the audit shall be done in such manner as may be prescribed. The institution shall furnish to the director an audited statement of accounts at the closing of each financial year, mentioning clearly the total receipts and expenditure during that financial year. Now, my lord, I pause here for a moment. This is with regard to see that there is no
profiteering.
Now, this has already been looked into by the committee. And in the committee, there is a provision that if anybody has any complaint, they make a, my lord, representation before the committee has to go into it, look into it.
No, but that is only on the complaint being made. What about annual information?
The problem there is, my lord,
yes,
they fix it for 3 years, my lord, in the fee, 3 years. So when I go back after 3 years, I'll have to give all this. It's already there. My lord, the chart also says, the schedule also says that I'll have to give the qualifications of the teachers, the salary being paid, and the expenditures I'm making, plus
that is for the purpose of fixing the determination of fees.
So, my lord, these documents have to be placed because there is a CA sitting there.
So there is an overlapping provision. What is wrong in it?
Wrong is, my lord, if the body which is there, what is the purpose, my lord? If for that purpose, a body has been created by the state, my lord, giving the same and similar power to another authority.
Is that body constituted under a statute?
Yes, your lordship.
Let us see.
Lordship 18, my lord. My lord would have it at page. Just giving it, my lord. My lord would have it at page 146, my lord, of the same book. My lord would have page 147, the objects, my lord.
Yes, just.
The objective to introduce the bill, namely so and so, is to make provision for fixation of fees of non-governmental education in the state of Assam and the matters connected thereto. As there is a pressing demand from various individuals, guardians of students, and the association for fixation of fees of so and so institution in the state of Assam, it has been decided to constitute fee regulatory and fee revision committee to fix the maximum fees to be charged from students, and hence this bill. Now, my lord would have the provisions. The non-governmental school is being defined. My lord would have page 152, section 3, the fee regulatory committee.
Composition, yes.
Composition. My lord, section 4, the committee shall consist of the following members: retired district and session judge, or a person who had been member of All India Services, having retired from post not below the rank of commissioner and secretary to government, or a person having member of Indian Police Service, having retired from a post not below the rank of additional director general. Then 2, one chartered accountant to be nominated by the government. 3, one civil engineer government approved valuer, because my properties have to be valued. Secretary so and so board. 1 represent a non-governmental education institution management to be nominated by the government. 1 academician of repute to be nominated by the government. Then my lord would see eight, powers and function. How the, my lord, body, the schools will place it before it. Here, my lord, E. Here, complaints or initiate suo motu with regard to collection of excess fee by a government institution as referred to here. Regulate the fees charged by the school and penal action for such provisions. Now, now, my lord, 11. My lord, 14, my lord has seen, is without any specification. The boundaries have not been defined. Here, my lord will see. 11. The fee regulatory committee shall determine the fee leviable for different categories of non-governmental education categorized by the committee after taking into account the following factors: location, investment. Well, it takes into account all possible
exhaustive,
my lord. Then, my lord, there is a free revision committee at 13, section 13. The composition is 13-2.
Retired High Court judge.
To be nominated by the government shall be chairperson. Now, my lord would see section 14.
Yes.
Here, my lord, 4. Every non-governmental education shall keep the accounts and records within the premises of the educational institution and shall make them available to all at all reasonable time for inspection by the fee regulatory committee or its authorized officer. And I have to keep it for under 5, my lord, for 7 years, my lord.
So
Then, my lord, 50.
Yes.
For contravention.
What is the other use? Any other use of these accounts?
No, my lord.
Nothing other than
Thing,
fees.
my lord. It's only for the purpose of the fee. For contravention of any provisions of this act or rules made thereunder, the school management shall, in addition to refund twice the amount of fee to the parents or guardian or to the person who has made payment, be liable to pay a fine of which shall be up to 5 lakhs, pay a fine which shall not be less than 5 lakhs, or to which may extend to 10 lakhs for the second contravention. For cancellation or withdrawal of registration, affiliation, no objection of the school on third and subsequent contravention by the concerned committee on the recommendation of the fee regulatory committee. So, there is a procedure prescribed. Here, it's the arbitrary and the self. It will depend on his whims and caprices of the director, who is already overburdened.
Otherwise, also, as the director is now with this Act of 2018, no role to play in the fixation of fees.
Lordship.
Why is he required to have a look at the accounts?
And my lord, he in the state body, in the fee revision committee, he would be an ex officio. My lord, 2-4.
Yes.
Page 158. The director of not the elementary, secondary education ex officio member of shall be the member secretary. So he is already subsumed into a committee. So what is the point in he himself having that satisfaction? The committee is drawing the satisfaction, my lord. So this is contradictory. And the rules, my lord, thereunder are also detailed. Everything has been, my lord, meticulously provided. Now, whether we are paying to the teachers or not, my lord, now all transactions, practically all schools, my lord, are online or in the bank. The teachers are also paid. As far as I know, my lord, maybe there would be some instances where they are paying in the acquaintance register still, my lord. But otherwise, it's online transfer to the accounts. My lord would see the requirement here. How we have to, my lord, proceed before the committee. My lord would have page 183, my lord. This is the form which we have to fill up, my lord. It starts from 182. My lord would have 185. Others are particulars. Details of teaching staff. My lord, name, designation, qualification, date of appointment in the school, subject, emoluments per month. Because, my lord, this is one of the factors which will go into weighing the expenditure that I have to make, so that whether my claim for that fees is justified or not. PAN number.
Yes.
Then, my lord, non-teaching staff, same thing. Results. Results for the last 3 years. Co-curricular activities. Then, my lord, would come to 186, my lord.
Yes.
I have to give these particulars, my lord, to show the facilities that I have, my lord. My lord, then part 4, financial information. The bank account that I maintain. Five, my lord. The query that fell from my lord, whether a rented premises can be used, my lord would have 5. Details of rent, name of the owner, relation of owner with school management, so and so, yearly amount of rent of building.
This contemplates a rented building also.
Yes, your lordship. So to that extent, this is the subsequent decision of the government, my lord.
Yes.
So to that extent, that act which fell from my lord on the very first day is not reconcilable. It has to be looked into afresh. Then,
Yes.
my lord, would have the next thing, details of income, accounting year, how much we get from different sources,
Heads,
my lord.
different heads.
We
yes.
have to, even, my lord, some schools, they have this habit of the in-house uniforms. That also is contemplated here. My lord would see 13 at page 188 down, uniform selling, shoe selling. So this, they have, my lord, applied their mind and taken whatever is conceivable to be brought in. Then, my lord, at page 190, total expenditure.
So almost an entire
Gamut has been
audit report is asked for. Almost.
Lordship. Lordship. Then, my lord, page 193, we have to work this down to individual student. My lord would have column 6, income per student, expenditure per student, fee proposed by the school per student. Then the total fee that would be determined by the bodies. So, my lord, if this exists, then, my lord, is required to take out from the 2006 Act the very heart of it, section 14. My lord, it cannot be the intent of an act that we will only register as institution. We will recognize it and then forget it. That's exactly what is happening under the 2006 Act. Now, my lord would proceed further to page 592, my lord.
Yes.
24. Now, this is the penalty if I don't fulfill the objects of the act, my lord. Now, my lord would see who can impose this penalty. Where any non-governmental education institution fails to comply or comply with the provisions of this act, or violates any of the provisions of this act or the rules and thereunder made thereunder or any order passed by the state government or the director under the provisions of this act. Now, my lord would read, the state government may, it's not the director, it's the state government may at any time after giving a reasonable opportunity of being heard, order for withdrawal of administrative recognition, closing down of the non-governmental educational institution. In the event of such closure, the individual so and so trust establishing and running the institution shall be solely responsible to the teaching and non-teaching staff, students, guardians, parents, and other concerned persons or bodies. My lord, this may not be very important too. So, my lord, here, it's not the director who will pass the order. It will be the state government. Now, my lord would see I'll come to 25 a little bit later, my lord. 28A, 594. So it was under 24 that the appellate provision was purportedly brought in, my lord. Now, my lord would see whether there is any methodology of grievance redressal is there. Any non-government educational institution or any individual government, non-government individual society or trust, as the case may be, establishing any non-governmental educational institution aggrieved by the order of director passed under the provision of this act may prefer an appeal before the state government against the order of the director within 30 days from the date of receipt of such order. Decision of the state government in such appeal shall be final and binding on the concern. One or two things I would like to point out. It's only the managing committee which can go. No other component of the school, even the parents, they have no access. And my lord, it's against an order of the director. And 24
talks of the
it's not a remedy.
This is the state government.
State government. So, my lord, from state government to state government, the same authority and appellate provision cannot be conceived because it's not in the name of the governor. And my lord would see 28A is not the answer to 24.
Precisely.
Now, my lord would see 25, just 593. My lord has seen that here the provision is that the institution will be closed. So that would be with regard to, my lord, something which is regard to recognition, provincialization, all those things, my lord. Now, my lord will see 25. Any government educational institution or school authority thereof failing to comply with any direction, it's vague to the core of it, my lord, issued to it by the state government or the director in discharge of their duties under this act. The chairman or president of the society or trust or individual association or individuals or any other person responsible for overall management of the institution or the owner thereof shall be held responsible and be liable to be punished with a fine which may extend to rupees 10,000 for the first offense, and in the event of commission of every subsequent offense, the fine may extend to rupees 50,000. Now, my lord reads this provision with 24. Again, this power can only be exercised by the state government. And that's further, my lord, fortified by section 3, which says it's the state government which will regulate. So, my lord, even if it is a provision under 25, then, my lord, I don't have an appellate provision. And my lord would see.
There is no procedure also.
There is no procedure.
Of, what order is passed, how it is to be complied.
What would be the procedure to be done, followed, how it will be done, what would be the offences which will be considered by the director, what will be done.
One more thing, Mr.
Lordship.
Let us see what orders can the director pass under this act. Let us see.
It's it's not defined anywhere. My lord will only have this, the recognition power.
Yes, power, section 3.
3. My lord, 2.
3(2).
On and from the commencement of this act, the establishment of a non-governmental educational institution or the opening of a higher class or the closing down of an existing class in any non-governmental education institution of the state shall be subject to the provisions of this act and rules made thereunder. And any non-governmental educational institution or any higher class established or opened otherwise than in accordance with the provisions of this act shall not be recognized under section 5 by the director and shall be closed down under section 24. Then, my lord, the power of the director is 4, my lord.
Just hold on. Close down under section 24.
24.
That is power of the state government.
State government.
Section 4, let us see.
The section 4, 2, my lord.
Hmm.
It says any individual can approach new schools.
This is grant or refuse to grant the permission.
Permission.
It is the one order.
One thing,
One.
therein you can have an appeal before the state government.
Yes.
But this, my lord, after when 24 comes in, the context of this also changes, my lord, because the director in the scheme of the things as it stands today, section 3 and section 24, he cannot pass a final order, my lord. It will have to be by the government. In the event of refusal under so-and-so, 4, my lord, so-and-so, the individual, aggrieved individual, association or individuals, non-government so-and-so may prefer an appeal before the state government, whose decision shall be.
So this is regarding anyhow, this is section 4 gives permission for establishment. That is the power of the director. Then what?
6, my lord.
Yes.
Administrative recognition. 5 for the new schools.
Just hold on. What is the difference between 4? That is a prior permission for establishment.
My lord, this is
And
with
then
new
registration.
schools. New schools.
New schools.
New schools. 6 would be for schools like me who are existing.
So this is recognition only.
Lordship, recognition only.
Yes. Then 7.
7, my lord,
Committee.
Constitutional Recognition Committee.
All right.
And that also, my lord, would see, it does not have any educationist there, my lord. All are educationists, but the term educationist as required, it's not there. But I'll show from the RT Act, it's been provided there. my lord. In RT Act, there is a definite procedure under the rules also, how you go about this. Here, just specification. You have just named everybody. But how to connect up, how to move about.
Once the school is established and recognition is granted,
Lordship.
any other matter, the director is virtually functus officio, except for committing a raid, conducting a raid.
Raid, asking for those monetary details. That much only, my lord. Then, my lord, 24. In the rules, my lord would find.
Yes.
Now, my lord would have to understand the rules in the context of the act. When the act has not given you that leeway or the directions, whether the rules can go beyond that. And my lord, it has not gone. It's still, my lord, vague. It only prescribes. My lord would see infrastructure, my lord, management, section, my lord, 605, scheme of management, which is 14, my lord, in the act.
Yes.
Each and every non-governmental educational institution shall prepare and submit to the director scheme of management with the following: power and functions of the chairman, procedure to be followed for constitution of managing committee, procedure for selection, appointment, and so, qualification, salary, service, code of conduct of students, manner of supervision, guidance, and control of teaching and non-teaching staff, students' fee structure, procedure for admission, manner of collection of voluntary contribution, procedure for taking disciplinary action, provisions for professional development of teachers, so and so. Now, my lord, if I may pause here, there are 100 schools, my lord. Where is your set guidelines that these are the norms or these are the manner in which you will have to do it? Plus, minus can happen. Now you will have, my lord, 100 sorts of proposals. Now, where is that, my lord, benchmark? It's not prescribed because the rule says, section 14 says, as prescribed. So, my lord, these headings, power and function of chairman, in a particular school, the chairman may be the boss. In another one, it would be the secretary or the manager. How do you, my lord, reconcile all this because you have not set my lord, a benchmark for this, my lord, which again goes to the root of the act, my lord. Then, my lord, here there is a procedure given, my lord, for suspension and the departmental procedures. Fine, my lord, very good. But if a person is aggrieved by that, where does he go, my lord? Because the Delhi Act 82 was there. Here there is nothing.
Yes.
And my lord, it's not even said that these things will have to be, this would be seen or this would be monitored. Nothing, my lord. So just making a prescription and leaving at it, they are washing their hands.
Saikya, there's one more question which you'll have to answer. Section 24, as far as we could find out, talks of consequences of non-violence, non-compliance of rules. Any other provision in the act? What is the consequence of non-compliance of rules? Please read. Have it, take a note.
Yes,
We could not find it anywhere.
Lordship.
Yes.
592 crore.
Yes.
Then, my lord would have 614. Again, the fund of the institution, maintenance of accounts and audit. General guidelines, my lord. Then, my lord, section 30, rule 33, 616, list of properties of the institution, which we, my lord, in details have given to the, because this will only have an bearing in the calculation of the fee. Then, my lord, section rule 34, it says 5% quota. But, my lord, with the coming of into the RT Act, this was raised, my lord. Now, my lord would have, before I place the Supreme Court judgment, my lord, I'll just have my lord's attention.
The form number 1
lordship
talks of lease also.
Lease.
So what the act doesn't allow a lease property.
The government, with the passage of time, had realized, but it forgot to go back and, my lord, amend those things.
Amend these things, yes.
And, my lord, in the act, the only lacuna, if I may say, my lord, the act, everything is said. But how you do it, what are the powers, how you exercise it, that when a power is being delegated by the legislation, they'll have to give the boundaries, my lord.
Boundaries are
not given. Now, my lord would have, I'll take another 10 minutes, 15 minutes, my lord. My lord would have the right to children to free education.
They know it.
RT Act.
RT Act. Yes.
My lord, we come under 2N subclause 4, my lord. Roman 4. An unaided school not receiving any kinds of aid or grants to meet its expenses from the appropriate government or the local authority. Now, my lord would go further. I'll just take my lord to make my lord take my lord to the rules. I'm just doing it. 18, my lord.
Section
18, my lord. Now, this is a central act, my lord. No school other than a school established, owned or controlled by the appropriate government or the local authority shall, after the commencement of this act, this, my lord, would relate to schools like me, my lord. Not the governmental sector, aided ones, but me, unaided ones.
Other than, yes, okay.
Be established a function without obtaining a certificate of recognition from such authority. Now, that school which is there under the 2006 Act, before the director I have to go. Now, under the RT Act, I have to go to an authority prescribed by the central government through the state rules to get this recognition. By making an application in such form or manner as may be prescribed. The authority prescribed under subsection 1 shall issue the certificate of recognition in such form, within such period, in such manner, and such subject to such condition as may be prescribed. provided that no recognition shall be granted to a school until it fulfills norms and standards specified under section 9. So, my lord, you are having a new set of guidelines which are coming in. On contravention of the conditions of recognition, the prescribed authority shall by an order in writing withdraw such recognition, provided that such order shall contain a direction as to which of the neighborhood schools the children studying in the derecognized school shall be admitted.
Any such guidelines been?
Yes,
promulgated?
state rules are there, my lord. I'm coming to that. 19, my lord, is the norms which have to be looked into for the purpose of, my lord, giving
Establishing the
the
school.
8. 21 is not attracted in my case. Now, my lord would come. And my lord, this was put to challenge before the Supreme Court in Rajasthan case as well as the subsequent, and it was said to be proper, my lord. Now, my lord would come to section 38. 38. Power of the appropriate government to make rules. The appropriate government may by notification make rules for carrying out the provisions of this act. In particular and without prejudice to the generality of the foregoing powers, such rules may provide for all or any of the following matters. My lord would have D. The manner and extent of reimbursement of expenditure. Forget, but that may not be into. My lord would have H. The form. G, my lord, sorry. The authority, the form, and the manner of making an application for certificate of recognition under subsection 1 of section 18. H, the form, the period, the manner and condition of issuing certificate of recognition. Detail, my lord, it should be. The form, the period, manner and condition of issuing certificate of recognition under subsection 2 of 18. The manner of giving opportunity of hearing under second proviso to subsection 3 of section 18. The other conditions to be performed by the school management committee under clause D, subsection 2 of 21. My lord, L, the salary allowances payable. Manner of preparing. Now, my lord, D, 24 deals with the teachers. Section 24 deals with the responsibility of teachers. 23, my lord, it's the qualification for appointment and terms and condition of services of teachers. My lord would have N, the manner of redressing grievances of that what I was trying to place before, my lord. The manner of redressing grievances of teacher under subsection 3 of section 24. The form, the rest, my lord, would be not required. And every rule here, my lord, has to be placed before the state legislature. Now, my lord takes up the rule. State rules, my lord. It's at page 241, 2011. My lord would have the other things. Page 252, rule 11. Every school recognition under section 18, other than a school established on or controlled by the government, so and so, established before the commencement of this act, shall make a self-declaration within a period of 3 months from the commencement of the act in so and so to the concerned district education officer regarding its compliance and otherwise the norms and standard prescribed in the schedule and the following conditions. My lord, everything has been given. Now, my lord would come to subclause 4, my lord, subrule 4. After the inspection referred to in 3 is carried out, the inspection report along with the recommendations shall be placed before the district level board notified by the government in that behalf. Recognition shall be accorded by the district level board and record of such shall be maintained by the district elementary education officer. Schools which do not conform to the norms, standards and conditions mentioned in so and so shall be listed by the so and so through a public order to this effect. And any time within the next 2 years, such schools may request the elementary education officer or for an on-site inspection for grant of recognition. The district elementary education officer shall place the inspection report.
Mr. Nair,
Lordship.
when you're referring to these rules, read rule D and E. 11(1)D and 11(1)E.
Lordship. The 1D, my lord, the school is open to inspection by an officer authorized by the government, autonomous council or local authority as the case may be. E, the school furnishes such reports and information as may be required by the Director of Elementary Education from time to time and complies with such instruction of the government, autonomous council as the case may be, and as may be issued to secure the continued fulfillment of so and so, so and so. I'll just
This refers to the provisions of Act of 2006.
six, my lord. But
Yes.
this, if I make a challenge to this, my lord, this may be bad. This is bad. But what I'm trying to show that there is a procedure prescribed here. If my lord can go further. Twelve, my lord, rule 12. If there has to be a withdrawal, how it will be done, my lord? Where the district elementary education officer on his own motion or on any representation received from any person has reason to believe to be recorded in writing that a school recognized under so and so has violated one or more of the condition for grant of recognition or has failed to fulfill the norms and standard prescribed in the schedule, he shall act in the following manner. First, my lord, there will be a issuance of notice.
Procedure.
Procedure, my lord. I'm on this, my lord. In case B, my lord. In case the explanation is not found to be satisfactory or no explanation is received within the stipulated time, the district elementary education officer may cause an inspection of the school to be conducted by a committee of 3 to 5 members comprising of educationists, civil society representatives, media, and the government representatives, which shall make due inquiry and submit its report along with the recommendation for continuation of recognition or its withdrawal to the district level board. So, my lord, it's not concentrated in a single person, my lord. There is a procedure. The district board level board shall consider and give the recommendation on the report of so and so. Shall forward the recommendation of the so and so, which shall be examined by him, and the orders shall be issued after giving due opportunity to the school liable to withdrawal. Any person in his school aggrieved by the decision of the director may appeal to the senior most Secretary Education within a period of 30 days. Then, my lord,
School Management Committee.
lordship. That, my lord, I may not detain your lordship. School Development Fund. Then, my lord would have 264.15. This is the teacher.
What Mr. Borbar argued, if you see School Management Committee,
lordship,
and the composition is much different from what is provided in Act of 2006.
Lordship.
This says there's a qualification for the purpose of
21.
21.
And 21, my lord, excludes me.
Yeah, all right.
It
21
excludes
is
me.
your
It
exclusion.
excludes me.
Yes, yes. Okay.
Then, my lord would have rule 18.
Yes.
23(3) of the, my lord, RTE Act. The salaries and allowances payable to and terms and condition shall be as such may be prescribed. So in 18, they have done that, my lord. Then, my lord,
20 grievance redressal system.
lordship, grievance for teachers. Therein, my lord has said you do it this way, but you say in the preamble that this is done to prevent exploitation of the teachers, but you don't give them anything. But
Yes.
my lord would have 30. Rule 30. Unfortunately, my lord, I missed out to place this before, my lord, when the matter was taken up.
Repeal and savings.
The existing acts, rules, regulation, executive instructions issued by the state government inconsistent with this rule shall be deemed to be void to the extent of inconsistency. So all those provisions there, wherein, my lord, it has been left to the discretion of the director, but a provision is being fixed here, will be void, my lord. Any act or authority so and so instruction
Action taken is same.
same. Action taken is same before that. But here those acts which I say, my lord, Because this is a rule under the Central Act, approved by the legislature. So anything that is contrary, so my lord, that 2006 Act as it stands today, at least to the extent, my lord, the elementary education is concerned, it goes on. My lord, I'll only place one judgment, 1989 4. 1989 4 is
Yes.
89 4 SS is 683. Herein the provisions of the Tamil Nadu Private Educational Institution Regulation Act 1966 was under my lord challenge. Now my lord would have the opening paragraph, madam. The question involved in these appeals relate to the virus of the Assam Tamil Nadu Private Educational Institution Regulation Act, so and so hereinafter referred to as the Act. The appellants are interested in running educational institutions which are covered by the expression private educational institution within the meaning of section 2F of the Act. The main challenge is directed against section so and so, so and so, so and so. The High Court struck down section 28 and upheld the other sections. Section 28 was, my lord, a section which gave exemption, power of the government to give exemption to certain schools. That was, my lord, struck down. That apart, the judgment where section 38 has been declared to be involved has not been. The provisions of the Act which are relevant for appreciating the ground urged by the appellant are as follows. Section 3 mandatorily requires a private educational institution to obtain the permission of the competent authority for the purpose of running it. The manager of such an institution has to, as required by section 4, make an application for permission in the prescribed form accompanied by a fee. Section 6 lays down the power of the competent authority to deal with such an application in the following terms. Grant of permission. On receipt of an application under section 4, the competent authority may grant or refuse to grant permission after taking into consideration the particulars contained in such application, provided that the permission shall not be refused under this section unless the applicant has been given an opportunity of making his representation. Provided further that in case of refusal of permission, the applicant shall be entitled to a refund of 1/2 of the amount of the fee accompanying the application. Now, my lord, para 3. The Act is impugned on the ground that it does not lay down any guideline for the express of the power by the delegated authority, as a result of which the authority is in a position to act according to his whims. The Act having failed to indicate the condition for exercise of power, the decision of the competent authority is bound to be discriminatory and arbitrary. It has been argued that restrictions put by the Act on the appellants who are running tutorial institutions are unreasonable and cannot be justified under subclause G of Article 19(1) of the Constitution of India. Now, what was the reply, madam? 4. The learned counsel appearing for the respondents has attempted to defend the Act on the ground that sufficient guidance is available to the authority concerned from subsection 2C of section 4, which enumerates the particulars required to be supplied in the application permission. There are 10. Ours is section 10, my lord. Perimeteria would be section 10. Then, my lord can skip it to para 6, my lord. The purpose of this Act is set to regulate private educational institution, but does not give an idea as to the manner in which the control of the institution can be exercised. The preamble which describes the Act for regulation is not helpful at all. Learned counsel for the state has said that objects and reasons for the Act are to eradicate corrupt practices in private educational institutions. The expression private educational institution has been defined as meaning a college, school, or other institution established and run with the object of preparing, training, or guiding its students for any certificate, degree, or diploma, and it can therefore be readily inferred that the purpose of the Act is to see such institutions do not exploit the students, and while they impart training and guidance to the students of a standard which may effectively improve their knowledge so as to do well at the examination, they do not charge exorbitantly for their services. But the question is how this objective can be achieved. Section 6, which empowers the competent authority to grant or refuse to grant permission for establishing and running an institution, does not give any idea as to the condition for which it has to fulfill before it can apply for permission under the Act, nor are the tests indicated for refusing permission or cancelling under Section 7 of an already granted permission. The concerned authority has been left with unrestricted and unguided discretion, which renders the provisions unfair and discriminatory. It has been urged on behalf of the state that since an application for permission has to supply the particulars as detailed in Section 4(2)(c), quoted in para 4, the Act must be deemed to have given adequate guidelines. Special emphasis was given by the Learned Council on subclauses 3, 4, and 5 of Section 4(2)(c), which asks for information about amenities for students, equipments, laboratory, library, and other facilities for instruction, and the names of teachers with their qualifications. Same, my lord. It may be noted that the Act, beyond requiring the applicant to make factual statements about these matters, does not direct the institution to make provision for them as a condition for grant of permission. The maintenance of any particular standards of these heads are not in contemplation at all, although certain other aspects, not so important, have been dealt with differently in so-and-so. Other sections, including so-and-so, 4B mandatorily requires the applicant to pay the prescribed fee. Section 5 gives prescribed direction regarding the name. Section 11 about the certificates to be issued. Section 11, obligatory to maintain accounts in the prescribed manner. But there is no indication whatsoever, this is what I was relying, about the legislative policy or the accepted rule of conduct on the vital issue of maintenance of academic standard of the institution and other requirement relating to building, library, and necessary amenities for the children. My lord, I can skip the rest and come to the, after that, my lord, the quoting. The only safeguard given to the applicant institution is to be found in the first proviso of Section 6, which says that the permission shall not be refused unless the applicant has been given an opportunity of making his representation. But that does not by itself protect the applicant from discriminatory treatment. So far as Section 7 dealing with the power to cancel the permission granted earlier is concerned, no objection can be taken to the first part of the section whereunder the permission may be cancelled in case of fraud, misrepresentation, suppression of material particulars, or contravention of any provision of the Act or rules. But the other ground on which the authority can exercise its power, being contravention of any direction issued by the competent authority under the Act, which, my lord, is what I am aggrieved with, again suffers from the vice of arbitrariness. Section 15, the relevant section in this regard, states that the competent authority from time to time issues such directions regarding the management of a private education institution as it may think fit. The section is too wide in terms without indicating the nature of such direction or extent within which the authority should confine itself while exercising the power. Similarly, the situation in a matter contemplated matter of exemption under the Act. The power to grant exemption is contained in so-and-so, quoted in para 2 above. The provisions of the Act indicate that the state government has been vested with unrestricted discretion in the matter of choice of the competent authority under so-and-so, also in picking up choosing institution for exemption under so-and-so. Such an unguided power vested on the government was struck down as offending Article 14 in an earlier case. A similar situation arose in K.T. Muppilla Nair, State of Kerala, wherein the Section 4 of the Travancore Kochi Land Act, so-and-so, all land subjected to burden of tax. Section 7 gave power to the government to grant exemption from operation of the Act. The section was declared ultra-virus on the ground that it gave uncanalized, unlimited, and arbitrary power, as the state did not lay down any principle or policy for guidance of exercise of the discretion in respect of selection under so-and-so. But here also, the same situation in a different form exists. My lord, similar is the position with Section 6 and 7 of the present Act. The Learned Council for the respondent state contended that by referring to Section 4, to particulars to be supplied in the application permission, it can be easily imagined that the competent authority has taken into account all that may be validly relevant for the grant of or refusal of permission. We are afraid this section cannot be saved by recourse to this argument in absence of any helpful guidance from the Act. Then, my lord, it goes on to discuss the Gold Control Act. and the case therein. And finally, my lord, at para 10, for the reasons mentioned above, the impugned section of the Act must be held to be invalid. These provisions are inextricably bound up with the other parts of the Act so as to form a single scheme, and it is not possible to sever the other parts of the Act and save them. In the result, the entire Act is declared unprovided. So, my lord, what I was trying to project, subject to what my lord would say, is that this Act, the legislative guidance as to how the things have to be taken forward, which my lord would find in the RTE rules, my lord. Same authority has done it, is absent. In that view of the matter, if the state tomorrow wants to bring up an act, because my lord, it's not something that I'm appearing for an institution I'm saying. My students, my child is also studying, my lord. I also desire that, because private sector cannot be done away with. Private sector unaided schools cannot be done away with.
Yes, that's right.
And one more thing, my lord, has to note. In a government school, there is no competition, my lord. But for our schools, there is competition. I cannot raise this because, my lord, there may be around 10, 20, 30 schools all over the state, which may be called as star schools, my lord, which is visible in the where, my lord, the person who can afford send their children. But the other schools, my lord, are budget schools, my lord. So we have to maintain that level of, my lord. It may not be possible in every school, but the endeavor will always be to maintain that standard so that the students who are coming from a particular section to us don't stop. So, my lord, by bringing in further unguided, uncanalized powers or requirements, my lord, the functioning of the schools would be at risk, my lord. This is my humble submission, my lord. The Act has to go in toto. The rules will follow its course. And, my lord, even if it goes, the state where it's not, because the RTE Act says all those things which is contrary to us goes. So in that view of the matter also, but my lord, we had come before your lordship prior to that. So, my lord, I had addressed your lordship on the other aspects. Also. This is my humble submission, my lord.
So I would like to give a detailed reply to the arguments.
When?
Immediately on reopening 7th or 8th lordship. In fact, I have prepared the written arguments.
11.
They have argued the case.
There's one query where you will come
That
prepared
regarding
with
the
that.
land.
No.
Land,
More
I
than
have
that,
already
more than
declared.
that, more than that.
Lordship.
Come to section 20. Under what situation will the director enter and make an inspection?
Lordship.
That is whims.
Yes.
Or if there is an information of
Yes.
violation. The Act doesn't say so. Act says director thinks fit.
Anytime.
All right, today I'll enter and inspect, I'll seize.
Director
For what
can
purpose?
for supervision also he can enter.
For what purpose? It doesn't say so. Section doesn't say so. When you are framing an act, it has to be specific. It can't be vague.
75 means.
See, and for what purpose? For what reason will he enter?
591.
The director or any officer in this behalf may enter at any time
Yes.
with or without notice
Hmm.
any place or building or premise which he has reasons to believe
Hmm.
is being used as a non-government education.
So, Mr. Saikia, just pause here.
Yes,
It doesn't talk of a recognized institution.
yes.
So that means this power is not for entering into a recognized institution. It
Absolutely.
is only for such a building which he has a suspicion that it may be
It may be
used
running a school.
as a school.
Yes,
No, wait. No, so that is a power given to enter a private building to an officer contrary to the CRPC. Contrary to the CRPC, sir. Wait. There is no suspicion that any offense is being committed. How can he enter? Because an unrecognized school, even if it gives a mark sheet, it is worthless. So what is the purpose? An educational institution without being a recognition
yes.
would be giving out worthless pieces of paper.
He have to justify, and that is why
Sir,
this
Mr.
word.
Saikia, that is what we are telling you. Justification has to reflect from the provision. What is the reason behind entry? It doesn't say so. On an information that certain violations are being committed, the director may conduct even a surprise check, right? That is all right. But this section doesn't say so.
This particular,
Unbridled power. Read.
this will not affect any of the writ petitioners here.
So is it your concession that this will not operate on a recognized
From plain
institution?
reading.
Yes.
Plain reading again, once more, Lord.
Yes.
Let us read it.
Then Ms. Saikia, then it will go,
Anytime.
then it will go otherwise also. Director has no business to enter a private building. If it is not a recognized school, it is simply a private building.
It's a private building.
What business, what authority does the Constitution of India give to a director to enter a private building?
We are looking this case from the perspective of the English medium schools or the schools who are here.
We are telling you, we need a better mechanism. We are telling you, we need a better mechanism. Your act at the particular point of time when it was framed may have had a very salutary purpose, but over a period of time, this is again an observation coming. Over a period of time, things have changed drastically. It needs improvement. You can't deny.
So far as this part is concerned, Lord.
Yes.
The first part. The second part regarding inspection and entering the premise, that Lordship, the
RTA Act also says, 2017 Act also says.
18 Act also.
So that is what we are saying.
He has
Provisions have already been put in place with proper guidelines. This is unguided power. He doesn't need any reason to enter.
Here.
Just read carefully.
Yes. Enter at any time with or without notice, any place or
Yes.
building or premise, which he has reasons to believe.
Yes.
This is the word.
Yes.
Most of the taxation language.
Yes. You're right.
Self-assessment.
Reasons to believe.
Reasons to believe.
But he doesn't need to record those reasons.
They cannot be aggrieved by this.
Saikia, if we take that interpretation, you will be put at difficulty.
No.
Because in that event, the power of entry into a recognized institution goes, which is not the intent. You can't enter a recognized institution even if there is a violation.
Where he has, Lordship, reasons to believe that it is being used as a non-government education institution.
Yes, now come to
It-
see.
It is.
Come to see.
No, Lordship, let me complete this. He will not enter any residential building for this purpose. He have to believe that there is a imparting of education in that building, number one, and there are inflow of students. So indirectly, it has given the scope of a public place.
Anyway, carry on. Now come to para C.
See, after making the inspection,
Yes.
the director or his authorized officer carry out the inspection shall furnish a copy of the inspection report to the manager or managing committee of the non-government education institution to act upon the report and for compliance.
So if it is not a recognized,
It is found,
if it is not a recognized
suppose
institution,
it is found that the school is not functioning. So he cannot go to C. He will stop at that point that it is, my belief was
that
wrong.
is what we are saying, Mr. Saikia. Things need to improve. This section virtually means that it is putting fetters on the power of the director in entering a recognized school.
Lordship, it's not like that, Lordship. It is not that he have to justify.
The section has to reflect that he has to record the reasons, then enter. Entry into a building is a very drastic
Entry
step.
into a building of a private person is different. But entry into a place.
Today he says,
Students
he
are
says that
coming.
I had some flying bird told me, gave me an information in the ear. This is being used at school. I enter and then there is nothing. The people will beat the director and throw him out. What will happen? So you need to improve these things. You cannot deny. Then tell us the answer of this query. That in light of this section, it doesn't talk of a recognized non-government institution. Can you not enter?
No, we have it.
Which other power under this act of entering a recognized institution? No other power.
In this act.
In this act, no other power is given.
Inspection or supervision.
Yes.
Yes.
So inspection and supervision of what?
Inspection of what? Suppose he has doubt regarding the scheme of management which
We
was.
understand, but the section doesn't give him power to enter a recognized institution. That's
Yeah.
what we are saying.
Or
Only a suspicion that it may be used.
that is a very limited scope. The other scope is or any officer authorized in this behalf. Who
Yes.
can authorize? The authorization can come from section 2018 Act also.
Yes, again and again, we are saying that there has to be a reconciliatory exercise. That is what we are
No,
saying.
these are certain imaginary situations which are being projected by the other side. Imaginary.
There is nothing
situations.
imaginary about 20. We are asking you whether your director can enter a recognized institution in light of the plain language of the
Yes,
section.
Lordship, he can, if he has reasons to believe that a school is functioning there.
It is a recognized school. We are telling you.
In-
It is supposing it is Don Bosco school,
Yes,
whether he can enter.
he can enter.
This section doesn't give him power.
This section,
Only in the event of suspicion, Don Bosco is a recognized school. Your director knows it. He can't have a suspicion that it is being used as a non-government educational institution. It's only dealing with a position wherein the school is being run without any information, clandestinely. That is precisely what this section is. Because recognized institution, there is no question of having a reason to believe. It is a school.
it is a school.
So
So
the-
for-
this doesn't. So for a violation by a recognized school, what is the power of inspection? That is already given under the
if we
RTA
read,
Act and the Fees Act.
no, fees, let us read section 20 B
Yes.
with
Yes.
the first line. Director or any officer authorized in this behalf
Hmm.
may make such examination of place, building or premise or inspect any school, etc.
Yes.
Documents.
Which building? Which building? This doesn't talk of even is the building which is referred to in section A, subclause A.
make
Any
su-
place, any place.
No, we are skipping A. Straightaway
That
we
is
come
why
to
I am
B.
saying, Mr. Saikia, that is why we are saying your section B had to say building referred to in subclause A.
No, here suppose
Yes,
he is not taking into recourse of A.
yes.
He can straightway go to B
Go to
also.
any building. Any building. It says any building. Any building for that matter.
For the purpose of examination, investigate collection of evidence to retain them.
For
as
what
lo-
purpose?
Purpose of examination.
For what purpose? What is
What
the use? How will that
Suppose-
information be
suppose-
used?
In the, suppose they are giving us that we have 100 numbers of classrooms.
Ms. Saikia, that is what we are again and again saying. This section doesn't authorize your director to enter a recognized school.
We have to go to the rule then.
Yes, rule, read the rule. Fine enough.
Rule 601.
Yes, let's see.
Inspection and supervision or enquiry institution for on other. Let us start with chapter 4
Yes,
of the rules.
yes.
Enquiry or inspection for registration and administrative recognition of.
Oh, that is
existing-
pre-recognition. That is all right.
Yes, then second,
Yes,
inspection for purpose of administrative recognition of established with
Yes.
prior permission.
that is prior permission.
Yes. And
Yes,
C,
yes,
inspection and supervision or enquiry of institutions for other occasions.
yes, all right. This
That-
doesn't give you power to seize. That is why we are again,
Seizing and inspection are two different aspects.
that is why we are saying your act and the rules are inconsistent.
No, my humble submission is, Lordship.
Yes.
Till now, it was regarding inspection, entering into the premise.
Hmm.
That has been taken care of by the rules.
Yes,
Now, only aspect is regarding the seizure power.
yes,
That I will address on the next date, Lordship.
all right.
On the point of seizure.
Yes.
Otherwise, this is guided, Lordship. His inspection, he cannot inspect.
Section 20 will not stand, we are telling you right now even, because
I-
it doesn't deal with recognized school at all. That is why this section will otherwise interpretation
No,
will create problems for you.
Section 20 have to be read with chapter 4 of the rules.
All
I'll
right.
try to satisfy it.
Try to say, all right. Yes. Hearing continues. Yeah, list on 11th
11.
September
Highly obliged.
for the status of the investigation.
Lordship, I'm on behalf of respondent number 1, Manoj Kumar Upadhyay.
No, we are not
When
of
is supposed to,
state government.
Mr. Deenat was appearing, right?
D Nath was not well yesterday.
Yes, madam, probably, madam.
Someone has to appear on his behalf. We had closed the proceedings, but we had kept it open for receiving the progress report. The review petition was closed by order dated 19/7. 19/7/2023. However, the matter was directed to be placed before the court for receiving the status report of investigation pursuant to registration of the FIR number 220/2023. Mr. D. Nath, Senior Government Advocate, is not available today. List again on 29th September at 2 p.m. for receiving the progress report.
Item 1 to 3.
On the last occasion, there was a specific query from this honorable court that what we are doing regarding the plastic waste lot.
Yes, yes.
So I have received some instructions. I would like to compile everything and place it through an affidavit, Lordship.
Okay, just briefly give us the outline.
Yes, the outline is, Lordship. We have thought about this also, that from waste to electricity, 2-3 rounds of inspection had earlier taken place, and it was found that the generation of plastic waste is not sufficient to sustain a project. And therefore, we have started this in regard to recyclable, reusable plastic. Following action has been taken. 144 number of material recovery facility in the ULB to segregate plastic. These recyclable, reusable plastics are either collected by rag pickers or moved to cement factories as alternative. In fact, right now we are supplying the plastics to 2-3 factories, Lordship.
Recycling.
For recycling in the cement factories for production of electricity. Then mechanized material recovery facilities are also to be established in the ULBs in SMB 2.0. An amount of 1,568.25 lakhs is sanctioned by Government of India in tranche 1 of SBM for construction of dry waste processing plant, material recovery facilities of capacity 185.5 TPD in respect of 42 ULBs in Assam. DPR has already been prepared and approved by SLTC meeting held on 13th April 2023. Tenders are awaiting contract for being floated. Tender was already floated. We have to finalize it. Further, 2511.75 lakhs is also sanctioned by Government of India in tranche 2 of SBM 2.0 and approved in principle by National Advisory and Review Committee on 6 March 2023 for construction of dry waste processing plants, material recovery facilities of 295.50 TPD in respect of 53 other ULBs of Assam. So this is regarding the plastic waste. Massive awareness campaign have also been done to segregate waste at source and reduce, reuse and recycle the plastic waste by the citizens of ULB of Assam. Now, how this mechanized material recovery facilities will work, that instructions I am requesting them. They came, but it was in a very rough way. They have told us. So I'd like to place how it will help to take care of the plastic waste.
Very well. There is one use which is now being extensively followed is to use it in construction of roads.
Yes,
that
yes.
improves the quality of the road.
Yes, Lordship.
The damage to the roads by the water is reduced.
Exactly. For Assam, it is very correct. And for some negotiation is also already taken place with National Highway Authority of India in this regard, Lordship.
If that can be worked out.
Lordship.
What about the allotment of land, Mr. Bora? Yes.
My lord, 16 bighas of land allotted to the.
Already allotted?
Already allotted. That my lord estimate has already been prepared and it was sent to the government. What you will find the feasibility assessment of land proposed for construction of sanitary landfill site.
Feasibility assessment. Where is the allotment?
Allotment, yes, my lord. That allotment has and lordship will find.
Yes.
16 bighas land has been allotted to the Sibsagar Municipal Board recently for construction of solid waste management project. That is there.
Provide this set to Mr. Das.
My lord.
Mr. R.K. Bora, government advocate states that 16 bighas of land have been allotted to the Sibsagar Municipal Board for construction of solid waste management project. Full stop. It is further stated that proposal has been moved for sanction of an amount of rupees 1,93,80,000 from the mission director SBM within bracket U regarding construction of the retaining wall, boundary wall of the sanitary landfill site for setting up of the solid waste management plant of Sibsagar Municipal Board at Betbari, Moza. Moza Gohen, Gaon, Sibsagar.
Yes.
Full stop. Latest progress report shall be placed on record for the court's perusal by the next date of listing, re-notify on 5th October. Or it can come on 12th October.
Item 3 is also with regard to Nagaon Municipal Board. The issue is same. But the thing is, their RDF plan, initially they have given a filed an affidavit saying that the RDF plan is in the pipeline. But perhaps subsequent decision came from the government that Pan Assam, every municipal board is going to come up with a RDF plan, because of which that plan, earlier plan has stopped.
Yes,
No, Lordship, earlier it was to be executed by the concerned municipal board itself, Lordship. Now the government has taken over the project, Lordship, for all the ULBs, Lordship. For Naga also, tender has already been floated, Lordship. It will be opened on 31st of 1, Lord.
All right. Mr. Naik submits, Mr. Naik appearing for the municipal board Nagaon in PIL number 38/22 states that tender has already been floated for establishing the solid waste management site in a plant in the municipal board Nagaon and is to be opened shortly hereinafter. He shall place the latest progress report on record by next date of listing, re-notify on 12th October.
My lord.
Lordship, in this case, I am appearing for the government.
For the government?
Yes.
Who is appearing for the municipal board?
No, one councillor was there, Lordship. Today he is not.
Appearing for the state authorities.
DPO.
Item number 4.
Lordship, I have received a analysis report regarding the drain waters which are going to the river Brahmaputra, Lordship.
What is the status?
The status is, Lordship, there is no standard for drain water samples. There is no such specification.
Obviously,
But
the issue is, Mr. Saikya,
Yes.
it falls into the river.
Exactly, Lordship.
That is the problem.
It falls into the river, and as although there may not be drain specification, but I have spoken to the concerned officer, it is much above the permissible limit. So I will have to come up with
Ultimately, it affects the river, sir.
yes, Lordship. So
So it should
therefore
be a
we-
matter of concern for everyone.
Yes, Lordship, we had a discussion with him also, Lordship, that ultimately STP, no? STP will have to be installed there.
That's
So
what,
I'll come up-
that's
I'll
what the
come up-
concern was.
Yes, Lordship.
When we put you that query,
Yes,
that was the concern that any inlet into the river,
yes.
you must treat it before it is
At least we
discharged.
could identify 9 numbers of major inlets to the river
Okay.
or outlets from
What,
our side.
what we told you from the other day, simple observation while going to Paralumuk, that place is choked with plastics.
Lordship,
Absolutely. So please put something which can be a regular cleaning
Lordship.
sort of thing.
And regarding plastic, Lordship, we have also done a survey. The plastic bottles below the size of 1 liter are mostly there dumped. The 1 liter and above 1 liter are always recycled or reused by the
That's right,
residents.
that's right.
So from 1st of September, we are banning that.
Okay, that's good.
So I'll come up with from our side, a proposal, Lordship.
Okay.
And regarding Bhorolu also, Lordship, we have found on that day sample was collected, there was some water coming inside from the Brahmaputra because the level was
Level
higher.
was,
So it gave a very good.
obviously that would be the river
But
sample.
we ourselves are saying that this is not satisfactory. So
Actually, what is
ultimately,
going into the river,
yes,
that
and
has to be checked.
I have sent that report which was placed before this honorable court of 2019. So they are on discussion, and in that lordship, 3 STP has to be installed in River Horolu. So we'll have to come out with some proposal regarding that also.
The anxiety is any kind of inflow of
Yes,
sewerage or other kind of discharges without treatment
lordship.
is not a happy
And
situation.
we have to redraw the drain lines also.
Drain
so
lines,
that,
yes.
There should be 3 or 4 STPs.
Yes.
So all the
All
drains will
drainage
culminate
system should go into that and then it should be
Exactly.
discharged.
Those things are also being at the stage of deliberation. So
Yes.
I'll come up.
And Advocate General submits that the reports of analysis of the water samples collected pursuant to the directions given by this court, direction given by this court on 26 July 23 have been received, and prima facie, it has been found that the samples contain
The pollutants which are below the-
pollutants far above the permitted standards. He further states that the state authorities have already started taking steps for addressing this issue, and a proper proposal shall be placed on record
Lordship.
for remedial proposal shall be placed on record for the court's perusal by the next date. List on 12th October.
Highly obliged. Deeply obliged.
Item number 5.
In this case, the other day we filed the affidavit, and today the other side was supposed to make their responses to our affidavit.
My lord, in the last occasion, we have made a submission that we'll respond after all the departments have filed their affidavit. My lord, in this regard, the railways, the forest, and the GMC has filed an affidavit. The district administration has not filed an affidavit.
What the district administration has to do with it?
My lord, it is-
Basically, it is water resources, railways and forests.
Yes,
They
my
are
lord.
the 3 concerned departments.
Regarding the eco-sensitive zone also, there was an order, my lord, on 25th, 2023, my lord, regarding the progress.
What is the
That
status of-
is regarding, that is by the forest department. To that effect, we have filed the affidavit.
Uh,
The latest status is lordship.
Hmm.
I'll give the sequence of events. May I please?
what about 26/7, Mr. Saikia? What has been done on the 26/7 indications regarding the Deepor bill?
There's 12 suggestions.
Yes,
So we are on process, lordship.
processing.
Yes, lordship. To that effect, one affidavit was filed also, lordship. To
Okay.
that effect.
Okay. So let us see about what he is saying
Yes.
regarding the ESZ
Yes, that lordship will kindly come to date 21/6/2023.
6/23.
Yes.
Yes.
In the 51st meeting of the expert committee for declaration of ESZ around protected areas, PCCF Wildlife and Chief Wildlife Warden Assam informed that in view of the public objections received on the earlier draft notification, the government of Assam has revised the proposal. After deliberation, the
So
committee.
presently, the status is that it is under
Yes,
consideration.
because we have to re-notify again because of the central government's.
By next date, they will come out with the
Yes.
notification. Ms. Saikia submits that the revised draft for declaration of the eco-sensitive zone has been placed before is under consideration by the concerned departments, whereafter it will be placed before the honorable cabinet
For forwarding
for
it to the
approval for necessary action. And counsel for the petitioner submits that he is desirous of filing his affidavit in reply after affidavits of all the respondents are placed on record. Re-notify on 12th October as prayed.
Obliged.
Highly obliged.
Item number 6.
Wait, please, your lordship, my lord, before my learned friend starts, my lord, we file an IA, my lord, for an implement. We have amongst us Mr. Dr. Jogendranath Fukan. He is the applicant, my lord, here. He is a renowned historian of the international level.
Yes.
He possesses some knowledge about the famous monuments of the.
We will definitely be benefited. And a few days earlier, we came across an article which has highlighted that there are some more monuments other than the Ahom dynasty monuments. In addition to that,
Yes.
uh,
Well, our respectful prayer, my lord, if lordships are pleased, my lord.
can you please bring my phone? I've taken a snap of that article. There are a couple of monuments just almost similar to that Stonehenge. It's about 20 kilometers from Guwahati. That was
That is Modon Kamdev, if I am not wrong. It is already under preservation.
I'm not
And
sure.
another is near Gwalpara.
Just let me check. Just let me check. I'll let you know. In the meantime, let Mr. Fukan come. Let him address us. We'll be benefited. If he wants, he can sit down and address.
My lord, he is 94 years age old, my lord, but he can stand and.
Yes, please. Tell us.
We have submitted, a list, but it is too short. So to give a detailed list, we need some time. So that.
So what do you want, sir? Let us know.
Comes together.
What do you want today? Do you want to address us today or you want?
A bit more time.
Okay.
And present it.
What is the application for? What is the?
For the implement as a response.
We'll just hear him as such. Yes. Yes, Saikya, this article refers to monoliths in Silpata. Yes, Silpata, a place about 20 kilometers west of Guwahati University. Monoliths are believed to have been erected by Austeric-speaking people who were the first inhabitants of Assam, as per many historians. Two have fallen on the ground, and about a kilometer or so to the east of Silpata, at a place called Rani, there is a large connection of monoliths believed to have been erected by the Jaintia leader in the 16th century AD. These are two things which are, we'll share the article with you.
Lordship.
Okay, so please see that some kind of action is taken.
I am personally speaking, I have not heard about it. Yes, Lordship.
It's just by chance
yes,
we
Lordship.
came across this article.
It was an Assam Tribune.
We should have known, well, it may have a lot of historical importance.
This refers to a very, very ancient kind of thing, because these monoliths, they are, you see,
Yes.
in Britain, people are flocking from all over the world for watching the Stonehenge. If there is anything of sort here, we need to protect and we need to show it to people. No, this is a letter to the editor. Letter to that.
It's a letter to the editor.
Letter to the editor.
Date, my lord. If I can know the date, my lord.
Date, exactly date I'm also not aware. I'll just let you know, because the day I took this snap,
Man,
25th August.
man, very recent, I'll get it.
Yes.
My lord, what he sincerely praised, my lord, today, that if he has, if lordship is pleased, my lord, if he is given. some
We'll
time,
record that, we'll allow him to address the court on this issue.
man.
What is the name?
Dr. Jogendranath Fukan.
Dr. Jogendranath Fukan, renowned historian from Assam, has approached this court by filing IS Bill 2487 of 2023, seeking impediment in the connected proceeding with the liberty to address the court on certain factual aspects which has a historical perspective and therefore will be relevant for the purpose of this proceeding. After considering the request made by Dr. Fukan, and considering his knowledge and expertise in this subject, we are of the view that the prayer deserves to be allowed. Accordingly, Dr. Jogendranath is allowed to intervene in the proceeding, to carry out necessary correction in the first title of the PI and list the matter again. After,
Ms. Chaudhary, what is the response of ASI? Okay, then it will come up on 12th October. In the meantime, you ask your authorities.
My submission, Lordship may give an indication about the site which
Uh,
is there in a later so later.
during
So that
the-
I can take the instruction from the Director of Archaeology.
PIL, so right, Mr. D. Sekar, Learned Advocate General Assam, and Mr. R.K. Dev Chaudhary, Learned ESGI, has sought some more time to seek response from their respective clients and place the matter before the court. In the meantime, the attention of this court has been drawn to letters to editor appearing in the English Daily Assam Tribune in its issue dated 25th of August 2023, wherein wherein a reader of the newspaper has mentioned about similar historic monoliths situated at historic sites belonging to the pre-Ahom era, which exists about 20 kilometers away from Guwahati University. According to the author of the letter, the monoliths are believed to have been erected by the Austric, AUSTRIC, Austric speaking people who were the first inhabitants of Assam. This court the prima facie opinion that the letter as published in the Assam Tribune requires to be taken cognizance of, and the matter calls for further inquiry. As such, Sri D. Sekar, Learned Advocate General Assam, is requested to seek further instruction and place the same before the court on the next date, list again on 12th of October.
At least someone has responded.
Yes. Now we're gonna.
Next.
Deeply obliged.
Can it be little?
Yes.
Dr. Fukan is saying that on 12th of October, he has a meeting with the UNESCO people in Assam. So can it be?
Because we fix these matters on a Thursday.
Minor.
That is the problem.
No issue.
He can address by VC if he wants.
Minor.
You may address through VC. Dr. Fukan,
Yeah.
we'll permit you to address through VC. All right.
Minor.
You can talk to Ms. Chamwa. He will organize the
Minor.
link and everything.
Bullet points if you want to take.
And if you can put in some written submission, brief submissions
Yes.
in writing, we'll ensure that they are taken care of. Okay.
Highly obliged.
Thank you. This is quite amazing that the gentleman has taken the trouble of coming to the court. We appreciate your efforts, sir. Thank you.
Item number 7.
file the affidavit. In the meantime, the south, my friend is saying the south is what with Guwahati zone. That another project is here. But the project is implemented by Assam Urban Infrastructure Investment Program. And that is not made a party. And we have received the info.
Forget it, this is not an adversarial kind of litigation.
We want to file an affidavit, my lord.
You want to file an affidavit?
Without a party, my lord, that's a we are filing.
We'll permit you.
No.
We will record in the order.
No.
Then council, Mr. Your good name, please.
Yes, Bora, lord.
S. Bora, Standing Council, GMC and GMD submits that for East Guwahati,
For southeast Guwahati, West zone.
water for supply of
Southwest-
drinking water to southeast Guwahati, comma, the work has been awarded to
Work is being project undertaken by Assam Urban Infrastructure Investment Program.
so and so. He prays for and is granted permission to file an affidavit on behalf of the said institution,
Yes.
entity कर दीजिए.
Millard, may I pray to say
Yes, yes.
something? Millard, the 15th June 23 order, your lordship, has till date not been complied because this affidavit has not been brought on record is what I am given to understand, Millard.
Check this record, my lord. What had happened, my lord? In a photo state, there is a defect and photo state. I will rectify it and it will come.
Send him a soft copy. Send a soft copy to Mr. Fukan. They filed an affidavit on 28 July, Mr. Fukan.
Already you have served a copy in the registry found on their
Because I'm this is not on record, so I'm not able to make even submissions in this regard.
What is the date of the affidavit?
The lordship will recall this order was passed after summoning the officers to court, Millard, and that
Mr. Fukan, the affidavit by respond number 5, we suppose, right?
Number 5, yes, Millard.
So it's already on record, page 368 to 380.
Lordship, respond number 3.
From respondent number 3.
GM.
Respond number 3.
Yes, it's not on record because
Mr. Bora submits that affidavit on behalf of the respondent number 3 has already been filed, but there are some defects and that he shall cure the same within the next 7 days.
Thereafter, on the next date, Millard, on 26th of July, your
Yes.
lordship had also asked about the that is the earlier PMC Gammon India was terminated for Southwest, and thereafter a new PMC had to be appointed. So that your lordship had asked them to apprise. That is on 26th July, Millard. If your lordship sees the 26th July order.
What about 26th July?
The tender has been issued, and there is only single tender. Now cabinet to take the decision. Single tender is there.
Single tender has been received. That's what last date Ms. Saikia told us. Yes.
Millard,
This
so
is already there, but what the cabinet has not taken the decision as yet. They'll take a decision, obviously. List on 12th October.
Obliged, Millard.
With due permission of your lordships, reference will be made on the passing away of late Niru Sharma Parazuli, advocate and member of the Guwahati High Court Bar Association.
Yes.
For order of reference, may I now call upon Mr. M.K. Chaudhary, President Guwahati High Court Bar Association.
Honorable the Chief Justice, the honorable judges present, the members of the registry present, my senior colleagues in the bar, and my other colleagues. We join in this gathering today on a sad occasion to mourn the death of Niru Sharma Parazuli, an advocate of this bar. We meet hundreds of lawyers every day in the court, on the corridors of the court, and also in the bar. And we know each other only as lawyers, and unmindful of the fact that some of our colleagues in the bar have some distinguished activities outside the field of law, and they are revered in the society for their creative activities. Late Niru Sharma Parazuli was one such lawyer whose activities, other than her role as a lawyer, has earned accolades, and that she depicted extraordinary talent and potential in her creative work. Being born and brought up in a Nepali family near Gangmo Than, which is a satra where Mahapurush Shankardev stayed for 7 years, more than 7 years, she was influenced by that. And being influenced, she was attracted to such Satriya culture. And eventually, she became an exponent of Satriya system of art by her performance as a dancer and as a singer. Besides, she earned name and fame as a poet and was invited by the Sahitya Academy on 7 occasions to attend literary meets representing our state, and also as a jury, and also as a speaker. She has also the distinction of being invited to International Conference on Fine Arts and Literature. We have lost an honest member, and her death is a great loss, not only to the Guwahati High Court Bar Association, but also to the literary and cultural fraternity of the state. And it will be difficult to fill up that vacuum created by her death. She leaves behind her husband, Sri Jayanta Kumar Parajuli, who is a practicing advocate, along with her near and dear ones. I, on my behalf and on behalf of the Guwahati High Court Bar Association, express our heartfelt condolence and pray to the Almighty for eternal peace of the departed soul. And may God give the husband and the other family the strength they need in these difficult days.
Mr. Mahim Chandra Deka, President, Guwahati High Court Advocate Association.
Honorable Chief Justice of Guwahati High Court, Honorable other judges, respected President, Guwahati High Court Bar Association, respected Chairman, Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, respected Additional Advocate General, Assam, Arunachal Pradesh, Mizoram, and Nagaland, respected Deputy SCI, respected senior advocates and esteemed colleagues in the bar, respected members of the registry. Today, we have assembled here to mourn the untimely sad demise of Advocate Mrs. Niru Sharma Parazuli, who passed away on 27th August last while undergoing treatment at Tata Memorial Hospital, Mumbai. She was about 56 years of age. She was born at Mazgaon, Bihali, in the district of Vishwanath, and after an illustrious career, she became an advocate of Guwahati High Court. She was not only an advocate, but a distinguished personality involving herself in various socio-cultural organizations of the state of Assam. She was an eminent writer in the state, Vice President of the Assam Lekhika Sangha, Vice President of the Assam Nepali Sahitya Sabha, former Vice President of the Assam Gurkha Sammelan. A prolific writer, artist, Parazuli was excellent in Assamese and Nepali language. She has many books to her credit, besides translation and editing works. She lives behind her husband, Mr. Jayanta Kumar Parazuli, an advocate of this honorable court, with a host of other relatives. On her death, we have lost a distinguished member of the legal fraternity and also a great loss to her family members. On my behalf and on behalf of the members of Guwahati High Court Advocacy, we convey our heartfelt condolences to her husband, Mr. Jayanta Kumar Parazuli, and other members of the bereaved family. We pray to the Almighty for eternal peace of the departed soul.
Mr. Sinmoy Chaudhary, Chairman of Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim.
My Lord, the Honorable Chief Justice, Honorable Judges of Guwahati High Court, learned members of the registry, staff of the registry, my esteemed colleagues in the bar. Lordship, we have assembled today to mourn the sudden demise of late Niru Sharma Parajuli, who was a member of this bar association and was an active practicing lawyer who succumbed to the serious ailment he had been suffering and was under treatment at the Tata Memorial Hospital on 27th August 2023 at Mumbai. She was 56 years old at the time of her demise. Late Niru Sharma Parajuli was born in the year 1967 and had her early education from Bihali Higher Secondary and obtained her degree from Vishwanath College. Thereafter, she studied LLB and took her LLB degree from the Guwahati University. Apart from her education in the degree level, she did MA in language as well as in Assamese literature. Also did her MA in Nepali and was a Hindi Bisharat. Thereafter, she got herself enrolled as a member of the Bar Council of Assam, Nagaland, etc. on 29/11/2000. And she also became a member of the Guwahati High Court Bar Association on 3rd December 2010. Lordship, apart from being a member of the bar, a practicing lawyer, she was at the same time a poet, a writer, and there are several books to her credit. She was an author, and on many occasions she took posts in other organizations, like she was secretary of Assam Gurkha Sanmilan in the year 2005 to 2008, then general secretary, Assam Gurkha Sanmilan, again assistant secretary, All Assam Lekhika Samaro from 2009 to 2014, joint secretary, Pub Guwahati Lekhika Samaro from 2008 to 11, working president, Pub Guwahati Lekhika Samaro from 2011 to till date, literary member, Bharatiya Gorkha Parisangha, assistant secretary, Assam Nepali Sahitya Sabha from 2007 to 2010, vice president, Assam Nepali Sahitya Sabha from 2010 to 2013. Thereafter also she worked as president, Assam Nepali Sahitya Sabha from 2013 to 2016, vice president, Assam Nepali Sahitya Sabha from 2016 to till date. Late Niru Sharma Parajuli was closely attached and participated in international seminars as well as a Nepali poet from Northeast India to Northeast Southern Writers Meet held in Hyderabad on 30th and 31st August 2008, organized by Sahitya Academy, New Delhi. Northeast India to Inner Cultural and Fairism Discourse Program held in Dharan Sansari, Nepal on 16 to 2013. Sahitya Academy, New Delhi as a member of the jury for the year 2016 Bal Sahitya Puraskar in Nepali and participated the same at Kolkata on 6 June to 8 June 2016. She attended Sahitya Academy, New Delhi in a Kavi Sanmilan, Northeast and South during the 29th Vijayawada Book Festival in collaboration with Vijayawada Book Festival Society in 2018 at Vijayawada, Andhra Pradesh. Lordship, she published many books, some were translations and some were her own creation, and she was equally good in as a author in Nepali and had to her credit many books of poem. Her sudden demise is a great loss to the High Court Bar Association, and it is a loss to the entire advocate fraternity. and Lordship, in her demise, the society has lost a very high quality author and a poet. At her demise, I pray to the Almighty that her departed soul may rest in peace, and also pray to the God to give enough strength to the husband she has left behind to bear this extreme loss.
Mr. Biswajit Goswami, Additional Advocate General, Assam.
My Lord, Honorable Chief Justice, Honorable Judges of this Honorable Court, members of the registry, my esteemed colleague. Today we have assembled here to mourn the death of late Niru Sharma Parazuli, an advocate of this Honorable Court, who was enrolled as an advocate by the Bar Council in the year 2000 and was also a member of Guwahati High Court Bar Association. Her husband is also a practicing lawyer of this Honorable Court. She was born in Gangmothan in Bihali in the present district of Biswanath. She completed her secondary education in Bihali High School and then completed her graduation from Biswanath College and postgraduate from the Guwahati University. She did her MA in Assamese language as well as Assamese literature and also MA in Nepali. She was also Hindi Visarad, and she took her LLB degree from the Guwahati University. A prolific writer, Niru Sharma Parazuli was proficient in Assamese and Nepali language. She has many books to her credit, apart from translation work and editing books of research value. She has already published as many as 10 books, both in Assamese as well as Nepali. She was also felicitated as a writer by the government of Assam. Srimati Niru Sharma was also General Secretary and Vice President of All Assam Lekika Samaroh and was also elected as General Secretary of Assam Gorkha Sanmilan, Working President of Assam Nepali Sahitya Sabha. She was also a good singer and dancer and was closely associated with many socio-cultural organizations of Assam. Late Niru Sharma was invited by Sahitya Academy, New Delhi, several occasions, among them in two-day Northeast and Southern Women Writers Meet held on 16 and 17 March 2018. She was invited by the Sahitya Academy, New Delhi in Kavi Sanmilan during 29th Vijayawada Book Festival. She was also invited by the Sahitya Academy, New Delhi as a member of the jury in the year 2016 Wal Sahitya Puraskar in Nepali and participated the same at Kolkata also. Many a times she was invited by the Sahitya Academy and accordingly she participated. She established herself in the field of Assamese and Nepali literature. Late Sharma, Srimati Sharma was also an exponent of Satriya Git and Nitya. She was born and brought up nearby to Sri Sri Gangmothan, which was established by great saint of Assam, Srimanta Shankardev, who was stayed there for more than 7 years. And that is why she was also well conversant with the Satriya culture, Nitya, Git, etc. Late Niru Sharma was a good human being and was also fighting for upliftment of downtrodden people. She breathed her last on Sunday, that is 27 August 2023 at Tata Memorial Hospital, Mumbai, while undergoing treatment, and at the time of her death, she was 55. I, on behalf of the state of Assam and my personal behalf, express deep condolence on the death of Srimati Niru Sharma Parazuli, an advocate of this honorable court, and pray for eternal peace of the departed soul and offer my condolence to the Pidip family. Namaskar.
Mr. NNB Chowdhury, Additional Advocate General, Arunachal Pradesh.
My Lord, Honorable Chief Justice, my Lord, and the Honorable Judges of the Honorable Guwahati High Court, member of the Registry, my Lord, and my esteemed senior colleague and member of the Bar. Today we have assembled here to mourn the untimely demise of late Niru Sharma Parazuli, a distinguished lawyer, writer, and a prominent figure in Assamese and Nepali literature. Late Niru Sharma Parazuli, also known her role as the Vice President of Assam Lekhika Sangha, Vice President of Nepali Sahitya Sabha, and former Vice President of Assam Gorkha Sanmilan. She was enrolled as an advocate under the Bar Council of Assam, Nagaland, Mizoram, and Arunachal Pradesh, and used practice mainly in civil side. She was renowned her creative writing, which spanned both Assamese and Nepali language. She was not only an advocate, but also a passionate contributor to the literary and cultural landscape of Assam. It is sad for the legal fraternity to lose a prominent soul, leaving behind her husband, Jayanta Kumar Parajuri. I, on my personal behalf and on behalf of the state of Arunachal Pradesh, pay my respectful homage to the departed soul, and may her soul rest in peace.
Mr. Anjan Kalita, Additional Advocate General, Mizoram.
My Lord Honorable Chief Justice of the Guwahati High Court, judges of the Guwahati High Court, members of the registry, my seniors at the bar, and my colleagues. We have lost another illustrious and multi-talented colleague of ours. Late Niru Sharma Parajuli passed away in Mumbai in short illness a couple of days back at the age of 56 years. Her husband, Jayanta Kumar Parajuli, is a practicing advocate, and we joined this bar, in fact, the same year. Though I personally did not have any opportunity to interact with her, but I am aware of her rich contributions to the literary space as a prolific writer and a poet. Late Niru Sharma Parajuli was born in the year 1967 in Behali, Mazgaon, in the district of Biswanath, and completed her schooling from Behali Higher Secondary School. Then she went on to complete her graduation from Biswanath College. Later, she obtained MA in English literature as well as MA in Nepali literature. Then she did her LLB from Guwahati University. She was a Hindi Bisarat also. During her lifetime, she penned many books on poetry in Assamese and Nepali language. Some of the noteworthy books are Kavitai Mur Vibhukha, an Assamese poetry collection, Vokma Korieka Sabdabhadaru, a Nepali poetry collection, Mathu Pramar Babe Emuthi Anubhav, an Assamese poetry collection, Bogi Bormar Bari, a collection of Assamese poem for children. She had also written Sapna Eti Mukta Akahar, an Assamese story collection. Let Niru Sharma Parajuli held many prestigious positions in literary world during her lifetime, such as Secretary Assam Gurkha Sanmilan from 2005 to 2008, General Secretary Assam Gurkha Sanmilan 2008 to 2022, the Assistant Secretary All Assam Lekhika Sangha from 2009 to 2014, and many more. She was a Vice President of All Assam Lekhika Sangha from 2022 till the time of her death. For her immense contributions, the government of Assam felicitated her under Vaha Gaurav scheme 2021 as a writer. She participated in numerous literary festivals and was a jury member of Sahitya Academy New Delhi for the year 2016 for Bal Sahitya Puraskar in Nepali. On her death, we have lost a bright and prolific writer and a lawyer, which is a great loss to our society. We want to convey to our colleague Jayanta Kumar Parajuli and to the whole bereaved family that our sympathies go out to you all at this difficult time, and pray to the Almighty to give strength to you all to bear this enormous loss. I, on my personal behalf, as well as on behalf of the state of Mizoram, condole the passing away of late Niru Sharma Parajuli, and I pray to the Almighty for eternal peace of the departed soul.
Mr. Ranjit Kumar Dev Chaudhary, Deputy Solicitor General of India.
Honorable the Chief Justice, Guwahati High Court, honorable judges present here today, members of the registry, learned senior advocates, and my colleagues in the bar. We assemble here today to mourn the death of, I would say, the premature death of one of our colleagues, Niru Sharma Parajuli. With her death, we lose a multifaceted personality. As has been spoken of by my previous speakers, she was a prolific writer not only in Assamese, she was a writer in Nepali, as well as she had some contribution in English as well. Now, taking all interests together, I must admit that it's a huge task when you are having interest in diverse fields. The time management. Here we have got a lady who has made her contribution in the field of literature as a writer, as a poet, as a dancer, an exponent of Kshatriya dance. She was also a lawyer, and she had immense contribution towards the upliftment of downtrodden children, I am told. Now, myself, at one point of time, I used to contribute some articles here and there. And I realized that to write something, you have to be in the right frame of mind, otherwise it does not come out. Just giving a lecture and having something to write about are two very different things. You have to have the right frame of mind, the right atmosphere, and everything done together is something really very great. Though I did not have the opportunity to meet her personally, I'm told that she was doing well in civil law. I, on behalf of the Union of India and on my personal behalf, pray to the Almighty to give strength to the bereaved family to bear this loss.
Ms. M. Kechi, Additional Advocate General, Nagaland.
My Lord Chief Justice, honorable judges, members of the registry, learned senior advocates, and my dear colleague of this esteemed bar. I stand here today to offer my condolence to the bereaved family of late Mrs. Neeru Sharma Parajuli, who passed away at the age of 55 years. Late Mrs. Parajuli joined the bar on 13/12/2010. Apart from being a lawyer, she was an eminent writer and had command over Assamese and Bali languages. She has many books to her credit besides translation and editing works. Late Mrs. Parajuli was also closely associated with many socio-cultural and literary organizations in the state, and for which she has received accolades. Mrs. Parajuli leaves behind her husband, who is an advocate of this bar, as well as a host of relatives. I express my grief on the untimely demise of an eminent writer and a lawyer, and today on my personal behalf and on behalf of the government of Nagaland and the people of Nagaland, express my heartfelt condolence to the bereaved and grieving family. May her soul rest in peace.
Now may we have the honor of reference by Honorable the Chief Justice.
My esteemed brother and sister judges on the bench, Mr. M.K. Chaudhary, President, Guwahati High Court Bar Association, Mr. Mahim Chandra Deka, President, Guwahati High Court Advocates Association, Mr. Chinmoy Chaudhary, Chairman, Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, Mr. Biswajit Goswami, Additional Advocate General, Assam, Mr. NNB Chaudhary, Additional Advocate General, Arunachal Pradesh, Mr. Anjan Kalita, Additional Advocate General, Mizoram, Mr. R.K. Dev Chaudhary, Deputy Solicitor General of India, Ms. M. Kechi, Additional Advocate General, Nagaland, then at senior advocates, members of the bar, members of the registry, and judicial officers. Today, we have assembled here to mourn the sad demise of Advocate Srimati Neeru Sharma Parajuli, who left us for the heavenly abode on 27th August 2023. Late Srimati Neeru Sharma was born on 15th April 1967. She enrolled herself as an advocate in the year 2000 and eventually joined the Guwahati High Court Bar Association in the year 2010. Late Srimati Neeru Sharma was widely known and respected for her eminence in the field of literature. She was a prolific writer in both Assamese and Nepali languages and has authored many books. She has many translations and editing works to her credit. Besides, she was closely associated with many socio-cultural and literary organizations in the state of Assam. She was the vice president of Assam Lekhika Sangathan, vice president of Nepali Sahitya Sabha, as well as the former vice president of Assam Gorkha Sammelan. She breathed her last while undergoing treatment at the Tata Memorial Hospital, Mumbai, leaving behind her husband, who is himself a practicing lawyer, and other family members. I did not have the opportunity to see Mrs. Sharma practicing or to meet her personally, but I'm told that she was respected by all for her gentle behavior, amiable disposition, and fair submissions in the court. Her contributions in the field of law and literature and her approach and behavior with the members of the bar and bench will continue to inspire the legal fraternity and the society at large. Her death is a great loss, not only to her family, but also to the legal fraternity and the literary world. I and my brother and sister judges on the bench fully associate with the sentiments and feelings expressed by the members of the bar. I, on behalf of my esteemed colleagues on the bench, my own behalf, and on behalf of the members of the registry, convey heartfelt condolence to the members of the bereaved family and pray the Almighty God to grant eternal peace to the departed soul and to give sufficient strength and courage to the members of our family to bear the irreparable loss. As a mark of respect to the departed soul, I request the learned members of the bar and bench to observe a minute's silence.
Time.
The court work on the judicial side will remain suspended for the rest of the day as a mark of respect to the departed soul.